the exam date for us? July 2nd? Okay.
Sir, he said no. Over there.
What's your last name?
I'm actually here for Robert McCoy.
Oh, you're standing
I
in.
was standing up.
Okay, thank you.
And I wrote that on the discovery.
Okay.
All rise. Thursday, before the city of Detroit is now session. Honorable Michael Wagner presiding. Proceeding, remain quiet.
Is your client in or out?
He said, I already let him know.
Yeah, but he needs to be brought in.
I know, I already told you. I already let him know.
Yes.
He's a judge.
Both. Do you have the form?
Leonard.
Did you sign it? Foster's in or out? Okay, she needs to come up.
Calling case 1558362, people of the state of Michigan versus Miss Ebony Love L.U.D. Foster. Ms. Foster is charged with one count of assault with a dangerous weapon punishable by a maximum of 4 years. Date and date and time for a probable cause conference appearance.
Rana Hadid on behalf of the people.
Good morning, Your Honor. Catherine Gorski on behalf of the defendant, Miss Ebony Foster. Standing to my right.
I'm sorry, did you hear your name?
Catherine Gorski on behalf of the defendant, Ebony Foster.
Could you
Standing.
spell it for the court reporter and give your P number, please?
Yes, Katherine. Last name Gorski, Gorski. P number 79101. On behalf of the defendant, Miss Ebony Foster.
Very well. Again, this is date and time scheduled for a probable cause conference. Have the people made an offer?
No, Your Honor.
And you're demanding your criminal examination?
Yes, Your Honor.
I do have the probable cause conference form in hand. Have you received discovery?
Discovery is not complete, Your Honor.
You have some discovery.
I have some. I was retained as of last night, so we are working on that, Your Honor.
Very well. I'm going to amend the form to indicate that you have received some discovery, but additional discovery needed.
Yes, Your Honor.
Good. The form indicates which witnesses would likely be called at the preliminary examination. However, the form is silent with regard to any reports, records, additional stipulation, requests, or motions. Is that for either party? Is that correct?
Correct.
That's correct, Your Honor.
The scheduled date for the preliminary examination is July 2nd. Does that create a conflict for you?
No, Your Honor.
Your Honor, the defendant has informed me she has a traffic violation. She's to attend. 36th District.
36th District Court? That's fine. You come here first. We'll make sure that they're aware, and when you leave here, you'll help.
Thank you, Your Honor.
All right, Ms. Foster, you do have a statutory right to a preliminary examination. You're scheduled for July the 2nd. We'll see you on that day, 5/16.
Thank you, Your Honor.
Mr. Leonard? You can remain there.
Oh, okay.
Calling case 1558635, People State Michigan versus Mr. Torres, Torez Leonard. Common spelling Leonard. Mr. Leonard is charged with 3 counts. Count 1, weapon carrying concealed, punishable by a maximum of 5 years. Count 2, weapon, firearm, possession by a felon, punishable by a maximum of 5 years. And count 3, weapon, felony, firearm. Mandatory 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mr. Leonard is served with the habitual offender, second offense notice, dated the date and time scheduled for the probable cause.
Brian Hadid on behalf of the people.
Good morning, Your Honor. For the record, Jeffrey Glazer, P46892, on behalf of Mr. Leonard.
Very well. Have the people made an offer?
No, Your Honor.
Judge, I'm sorry, I might add, I'm standing in for the attorney on record, Robin McCoy, and that is with permission of the defendant to do so. Is that correct, Mr. Leonard? Thank you.
The people have not made an offer, and the mandatory,
We-
Mr. demanding his right for criminal examination, demanding his criminal examination.
He is, Judge.
Very well. Have you received discovery?
I have acknowledged receipt, Your Honor.
I do have the probable cause conference forms in hand that indicate who witnesses would like to be part of the criminal examination. The people have also indicated that they would be introducing the register of actions for the elements with regard to the felony possession charge. Is that correct?
Correct.
I see no other reports, records, stipulations, or such motions to be offered by either party. Is that correct?
Correct.
Correct, Your Honor.
The date of July the 2nd, which is the scheduled date for the criminal examination, does that create a conflict of interest?
No, Your Honor.
Mr. Williams, you have a statutory right to a criminal examination. You're scheduled for July the 2nd. We'll see you on that date.
Thank you, Your Honor.
Do you know what you wanted to do?
No, I don't. Is there an offer?
No. Did you get discovery?
Nope. You got it?
No. You'll get it. Here, you want to read my file on it if you want to hold it.
See if he's lined up.
Now, okay. Now, I have a series of photos. I don't know exactly how we're going to deal with them, but I got copies for you.
You want an appearance or an appointment?
I'm not saying I'm gonna do it like you. I mean, that's why I don't intend to. I do intend to use a couple of them. Specifically, I know.
You want us to hold? Okay. I think July the 2nd is the date. Yeah. Let's do it before they hold this. Hey.
McKnight and White. One of the probable cause. I think that's supposed to be.
White is at PCC.
Okay.
Fill this out if you guys want to hold.
What is?
2 counts. Heroin, cocaine. And then the other one's an exam.
What is?
We're ready on the exam. It's 1 count of C stuff.
Oh.
It's, I don't know why he's holding on that one. The
Probably
C-
just they came to PCC
Oh,
and was
okay.
whatever.
All right.
Because is there a confession or something?
It's in plain view, and he's in the car.
Just a question. Do you know if the officers, when they arrived, did they have video, did they have cameras in their car?
I don't know. I have to ask the
Can
officer.
you check on that? That is kind of important.
Well, you need a discovery order for them
Okay,
to get it.
all right.
Okay. We're just waiting on their report.
Do they have, they've got one here that I can fill in?
Yeah.
Okay.
I give you that form. Oh. And you don't know who your co-counsel is? Hi.
George Bliss.
Bliss? Mm-mm. What's your last name?
Williams.
Williams? No. I don't have a Bliss.
destruction of personal property less than 200. That is a 93-day misdemeanor not subject to a preliminary examination. Mr. Bailey is served with a visual offender fourth offense notice. Today is the day and time scheduled for a probable cause conference. Appearances, please.
Rana Hadid on behalf of the people.
James Anderson on behalf of Mr. Bailey. Your Honor, we're electing to have our preliminary exam.
For the record, have the people made an offer?
No, Your Honor.
Defense has already indicated that they choose to have their preliminary examination. I do have a probable cause conference form in hand. Have you received discovery, sir?
No, I have not. I'll be requesting that today.
The people have indicated on the form which witnesses would likely be called at the preliminary examination. However, the form is silent with regard or respect to reports, records, stipulations, requests, or motions by either party. Is that correct?
Correct.
Correct.
The date of July the 2nd is the date that is scheduled for a preliminary examination. Is that a date that creates a conflict for anyone?
No, Your Honor.
It's good for the defense.
Very well. Mr. Bailey, you have a statutory right to a preliminary examination. Your schedule is currently for a date of July the 2nd. We'll see you on that date, sir.
Thank you.
Thank you, Your Honor. Thank you.
And what, this is BCC also? By none, I would call them both together.
What about McKnight?
Counsel. You don't have to be named. Calling case 1556308, People of State Mission versus Mr. Brian Patrick White. Mr. White is charged with 2 counts. Count 1, controlled substance possessed less than 25 grams of a mixture containing the controlled substance cocaine, punishable by a maximum of 4 years. Count 2 is the same charge, however, the controlled substance is heroin. Again, both individually punishable by a maximum of 4 years. Mr. White is served with a visual offender third offense notice. Today is the date and time scheduled for a probable cause conference. Appearances, please.
Rana Hadid on behalf of the people.
Good morning, Your Honor. Christine Longstreet appearing on behalf of Mr. White, who's standing to my right.
Have people made an offer?
No, Your Honor.
No offer.
And Your Honor, we would like to proceed to examine this case.
Very well. Have you received discovery now?
I have, Your Honor.
You have?
I have,
I
yes.
put it in the form to indicate that you have received discovery. The people have not indicated which witnesses would likely be called into exam, so
We did not.
plain.
I'll amend that. I think it's July 2nd. Mayor Pro.
Yes. Okay, the people have indicated which witness would likely be called at the preliminary examination. The people also indicated they would be introducing either the preliminary analysis or the scientific report indicating that the controlled substance or the analysis of the controlled substance make a determination if it is in fact a controlled substance. There are no other records, reports, stipulations, requests, or motions indicated upon the form that would be offered by either party. Is that correct?
Yes, Your Honor.
The date for the preliminary examination July the 2nd. Does that create a conflict for anyone?
No, Your Honor.
Very well. Mr. White, Mr. White, you do have a statutory right to the examination. You're scheduled for July the 2nd. We'll see you back on that date. Bond is continued. It's not urgent.
Thank you, Your Honor.
Are we ready on any other cases? Are we ready on the Smith case?
Yes.
Okay, just let me get to the defense.
Virgil Smith. Mr. Smith is charged with 4 counts. Count 1, malicious destruction of personal property, $20,000 or more, punishable by a maximum of 10 years. Count 2, assault with a dangerous weapon, punishable by a maximum of 4 years and for $2,000. Count 3, weapons, felony firearm, mandatory 2 years, consecutively with and preceding any term of imprisonment imposed for felony or potential felony conviction. Mr. Smith is also charged with 1 count of domestic violence. That's a 93-day misdemeanor, not subject to a preliminary examination. Today is the date and time given for the preliminary examination. Appearances, please.
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan, P number 39570.
Good morning, Your Honor. Dr. Dillard appearing on behalf of the defendant, Mr. Smith, P number 22802.
Very well.
The people's,
Please proceed.
yes, the people's witnesses have been sequestered.
The defense witnesses have been sequestered.
Very well. I
Prior
will
to,
give the sequestration motion just in case there's anyone else in the courtroom. Do you have an officer in charge? Are you asking for any exception to the sequestration order?
yes, Your Honor. Stand up and give your names.
Detective Jeffrey Williams.
Okay, you're going to have to use more voice than that.
Detective Jeffrey Williams.
Thank you. Mr. Dillard, is there an objection to the officer in charge remaining in courtroom?
No, Your Honor.
Now, you had 2 officers
Yes.
stand up. You have co-officer in charge?
Yes.
Okay, your name, sir.
Investigator Michael Jameson.
Jameson.
Yes, sir.
Very well. No objection to the...
No, Your Honor.
Let me ask you, did I give you my copy with the drawings on there? Let me just make sure I can see my...
If there is anyone else in the courtroom that will testify on this matter, has anything to offer by way of testimony, or anyone that was present at the location of 18601 Webster, City of Detroit, on the date of May the 10th of this year, 2015, if you were present for this incident, that would cause you a witness, even though you may not believe that you are. Again, or if you have anything to testify to, or anything to offer by way of testimony, please step from the courtroom. Should you remain in the courtroom, listen to the testimony of other witnesses. You may be barred from testifying at any time. Seeing no one leaving, people have indicated they have sequestered their witnesses. Defense has also. Any other preliminary matters?
Yes, Your Honor. I believe counsel per the preliminary examination, examination conference stipulates to the estimate on the value of the vehicle, which was a 2015 Mercedes-Benz.
So stipulated for the purposes of exam only, Your Honor.
Your Honor, based on the review of the damages to the vehicle, the company had determined the vehicle was a total loss, and the total value is $34,586.64. People will call their first witness.
Before we do that, ladies and gentlemen of the press, there's going to be a number of witnesses called today. I have no idea how many. I am indicating that you cannot show the faces of the witnesses. You can film from the head down or the neck down, or you can bubble out or obscure the face. No problem with the voices, but do not show the faces of the witnesses. I do understand that one person, I believe it's the complainant in the case, has made a press conference, so that person has already been exposed to the press, and he's free to show the complainant's face. So.
The people are calling Michael White.
Before you sit down, sir, your name is Clovis Porter? Michael White. Raise your right hand. State your full name. Michael White. Swear or affirm to tell the truth, whole truth, nothing but the truth? Yes, sir. Please have a seat in the witness chair, sir. Your witness.
Sir, I'd like to direct your attention back to the date of May 10th, 2015, approximately 1 in the morning. Were you on Wexford Street?
Yes.
Okay. And is that in the city of Detroit?
Yes.
And do you know Virgil Smith, Jr.?
Yes.
Do you see him seated anywhere in this courtroom?
Yes, ma'am.
Could you point him out and tell me what he's wearing?
Gentleman right there in the brown suit, I think that's brown.
Indicating for the record the witness has identified the person of the defendant.
Yes.
In the early morning.
One second. So you're going to have to project your voice more, or one of the deputies help adjust the microphone. You're going to have to speak directly into the court microphone. I know there's some other microphones there that are from the press, but you're going to have to, it has to be a little bit closer and speak directly.
Yes, sir.
Okay.
Now, you live on Wexford Street?
Yes.
And do you recognize the defendant from likewise living on Wexford Street?
Yes.
Okay. How far is your house from his house?
It's across the street, one house over.
Okay. In those early morning hours, did you hear something that caused you some concern?
Yes.
Could you tell me what it was that you heard?
Well, first, I was on the couch sleep. I woke up, I heard something that sounded like somebody running. And then, like, I heard shots, boom, 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 and I hit the floor.
And now let me stop you there. You indicated you heard a series of shots.
Yeah.
Approximately how many shots did you hear?
Oh, God, I don't know, maybe 8, 10.
Okay. And did they sound like they were relatively close?
Yes.
Okay. And you said you hit the floor.
Yes.
The sound of the gunshots were so close that you thought you were in danger of being hit?
Objection, that's leading.
Okay, I'll rephrase. Why is it that you hit the floor when you heard those gunshots?
Because they sounded close.
Okay, they sounded close. And what did you do after the gunshots stopped?
I looked out the window to see, kind of peek to see what was going on. I heard my wife running around upstairs. I guess she was looking out the window as well.
Okay. And did you make any observations when you were looking out of the window?
At one point, I mean, you know, I'm up and I'm peeking in and out of the window. At one point, I saw a white car pulling in the driveway across the street, directly across the street from me, a white SUV. And at one point, it just pulled in the driveway. It sat there for a second. When I looked out again, it was backing out, and it went south on Wexford.
Did you ever see Mr. Smith in the time period after you heard the gunshots?
Yes.
And where was it that you saw him?
Walking down the street. I went outside at one point because my wife said something was going on down at
Objection.
Okay. At some point, let me just stop you there. Your wife told you something, is that correct?
Yes.
And that caused you to look out?
That caused me to go outside.
Okay. And is that when you made the observation of Mr. Smith?
Yes.
Okay. And did you see Mr. Smith walking in any particular direction?
He was walking south on Wexford.
And is that significant to you at all?
I was worried that there was a problem at my stepson's house. He lives on the corner of Wexford.
And your stepson, his name is?
Carlos Cade.
And do you know whether or not Mr. Smith and Mr. Cade are friends?
Yes.
They are friends.
Yes.
So when you saw Mr. Virgil Smith, was he walking toward the direction of your stepson's house, Carlos Cade?
No, he was walking from that direction.
Okay. And did Mr. Smith address you at all, or did he say anything to you?
Well, I asked him if everything was all right.
You asked him if everything was all right, and you were able to observe him?
Yes.
What did he say at that point in time?
Domestic violence.
He said domestic violence, and what else did he say?
I shot. I put so many bullets in her car, it won't start.
Okay. And did he ever indicate whose car he was talking about?
I believe he said.
Objection is what he believes. Either he heard whose car he was talking about, or he did.
Your Honor, that's a figure of speech that people use.
Certainly, you can rephrase the question.
Okay.
You can inquire into it.
Sir,
certainly people do that all the time.
Okay. Sir, when you say, I believe he said, was that just a figure of speech you're using?
Yes, figure of speech.
Okay. So he said he shot at his ex-wife's car.
Objection. He didn't say that, Your Honor.
He did.
He just said, I believe, and then she came back and led him.
No, she didn't, counsel. She came back and said, he said it, but he prefaced it before with, I believe. She came back and he said that is just a figure of speech. So the balance of what he said is not, it's not like it was never said. He said that. People say all the time, I believe when they know. It's just, it is a figure of speech. And he indicated that.
So he said it was his ex-wife's car?
Yes.
Okay. So the sum of total, what he told you is when you said, is everything all right? He said domestic violence. I shot at her car so many times it won't start.
Right.
At that point in time, did he ever say, help me, call the police or anything of that nature?
That's leading, Judge.
No, I'm asking him specifically, did he say these things?
What answer was suggested, Counsel?
See that did he help? Leading was help you or?
No, if the answer could be yes, the answer could be no, the answer could be I don't know. If the person asks a direct or pointed question, which cuts down on confusion, doesn't make it leading. It would have been direct if she said, and this happened, didn't it? That would be the leading. If or what is not, does not make it leading because you frame the question in such a way that the person is not confused as to what you're asking. Let me hear it now.
Thank you. Did he ever ask you to call the police?
No.
Did he ever ask you for help?
No.
Nothing further of this witness.
Okay. Good morning, Mr. White.
Good morning.
Now, am I correct that I heard you just now testify on direct examination that prior to hearing a series of shots, you heard someone running?
That's what it sounded like.
Okay. Now, did you have a chance to see the person who was running?
No, what happened? I'm laying on the couch, right? I'm asleep.
Well, just help you with the question. Did you see the person running?
No.
Okay. But the running noise that you heard was prior to you hearing the shots?
Absolutely.
Okay. Now, and you also said that you did not see a weapon in Mr. Smith's hands?
Right.
At no time that evening?
No.
Now, would you testified also that you heard Mr. Smith say that, use the words domestic violence?
Yes.
Did he say to you who was committing domestic violence?
No.
Did he say he had committed domestic violence?
No.
Now, you also testified that he made some reference to the car being shot at.
Yes.
And he prefaced by that is he said that he shot the car up so that it would not start.
Yes.
Now, he never said he fired any shots at anyone, did he?
No.
He never mentioned that he fired shots at his ex-wife, did he?
No.
Now, when you saw him walking down the street, was he naked?
No.
Did he have clothes on?
Yes.
Do you recall what kind of clothes he had on?
Dark T-shirt, dark sweatpants, look like.
And can you tell me approximately, sir, how much time after the series of shots did you see Mr. Smith walking outside?
5 minutes or so.
Now, did you ever have a chance to actually walk up on Mr. Smith and look at him closely?
May have been as far as we are right now.
So you were not able to notice any injuries that Mr. Smith may have sustained?
No.
Objection assumes facts not in evidence.
Well,
first, let's step back. The witness testified as to a distance which the record will not be able to see. He said the distance from me to you.
Correct.
So first we have to put that on the record so we have an understanding of the record will accurately reflect what that distance is. Now, there are some measurements that are on the floor that will show you approximately what the distance is in a lateral way from the witness, and you can make some determination.
Mr. White, if you would look at the corner down here, can you see that number on the blue? It says 4.
Well, you can do that. He's already said how far he from you to him.
Okay.
All you have to do is agree on what that distance
Okay.
is.
Would you, looking at the measurements, say he was approximately 10 feet from you?
10 feet.
Okay.
Yeah.
All right. Now, were you able to observe whether or not he had any injuries?
No.
At any occasion, any time during the evening, did you have an opportunity to see a person by the name of Anestia Thomas?
No.
During that evening, did you have an opportunity to see any female walking in that area?
No.
During that evening, did you have an opportunity to see your son walking in that area?
No.
Nothing further, Your Honor.
Mr. Smith, did Mr. Smith indicate to you in any way that he needed any type of medical treatment?
No.
Did Mr. Smith indicate to you in any way that he had been injured?
No.
Did Mr. Smith indicate anything other than domestic violence? I shot her car so many times it won't start.
That was it.
Nothing further.
Nothing further, Your Honor.
You may step down, sir. Is this witness be released?
Yes.
Yes, Your Honor.
You're free to go, Mr. Smith. Mr. White. Raise your right hand. State your full name. Carlos Cady. You swear or affirm to tell the truth, whole truth, nothing but the truth. Please have a seat in the chair. Speak directly into the microphone, sir.
Sir, could you state your name, please?
Carlos Cade?
And do you stay on Wexford Street?
Yes, I do.
And from your house on Wexford Street, can you see the house of Mr. Virgil Smith?
Yes, I can.
And does he also likewise live on Wexford?
Yes, he does.
What is the distance between his house and your house?
The left of the block. The lady's on one corner, I stay on the opposite corner.
Okay. And you are friends with Mr. Smith?
Yes.
And you socialize with him?
Yes.
Okay. Now I'm going to direct your attention back to the the early morning hours of May 10th, 2015, around 1 in the morning. Did something unusual happen?
Yeah.
Okay. Prior to what was unusual happening, did you hear some gunshots?
Yes.
Approximately how many gunshots did you hear?
Like 5, maybe.
Okay. You said you heard about 5.
I didn't keep track. It's not uncommon to wear.
Okay, but you did hear gunshots?
Yes.
Okay. Now let me just ask you, through your friendship with Mr. Smith, do you know him to own weapons?
I know he has a gun.
Okay. Do you know him to have some type of assault rifle?
No.
And what type of gun do you know him to have?
Grandfather's rifle, I think, some kind of old rifle.
Okay. And you're saying at this point he's never shown you or told you anything about having an assault rifle?
No.
And you're saying that under oath?
Yes.
Okay. Now, let me just backtrack a little bit. You gave a statement to the police, is that correct?
Yes.
And the police made several efforts to take an additional statement from you, is that correct?
Yes.
And you never complied with coming to the police and giving them an additional statement, is that correct?
Correct.
Okay. After you heard the gunshots, what happens next?
Like 15, 20 minutes later, I hear a knock on the door.
And is that your estimate of time?
Roughly. It's movie night. We were drinking and watching movies.
You were drinking and watching movies? Okay. So you didn't time it, that's just your estimation of time, is that correct?
Yeah, guesstimation.
A guesstimation?
Yeah.
Okay. And did something happen after you heard the gunshots?
Heard a knock at the door.
Okay.
Got up.
And what happens?
Looked out the window. Saw Anistia. I figured her brother would come back in from hanging out. Opened up the door. It was just her.
Now let me stop you there. You said Anistia? Is that
The ex-wife.
okay? The ex-wife, Virgil Smith's ex-wife, and you had met her on previous occasions,
Yes.
and you had socialized with her and Mr. Smith.
Yes.
You had been to their house. They had been to your house.
I've been with her at his house. Yes.
Okay.
I've not been to her house.
Okay. And she was at the door, and she was by herself.
Yes.
Could you tell at that point whether you saw any injuries?
Not till she stepped in.
Okay. And she did in fact step in?
Yes.
And what, if anything, did you see at that point in time?
She had a smudge on the side of her lip, and she was showing us her hands.
And when you say smudge, what kind of smudge?
Blood, it could have been blood.
Okay. And did you indicate in your statement to the police, first of all, when you gave your statement to the police, were you trying to be truthful?
Yes.
Okay. And did you indicate to the police that she had a blood smear on the left side of her face?
Yes, on the left side.
And she asked to clean up?
Yes.
Okay. And you saw injuries where else?
On her knuckles.
Okay. And did you see any injuries anyplace else?
No.
Okay. Now, she asked to come in to clean up, is that correct?
Yes, she asked to come in, and we insisted that she went to clean up.
Okay. Now, at some point in time after that, did you see Virgil Smith?
Not till after she left.
Okay. And let me get the sequence of her leaving. At some point in time when she was at your house, she asked to use the phone, is that correct? Or she was using the phone, correct?
She was on my girlfriend's phone.
She was on your girlfriend's phone, and could you tell she was talking to 911?
Yes.
And she was talking to 911. Did you take the phone from her?
Yes, I did.
You took the phone from her while she was trying to call 911, while she was speaking to 911, correct?
Objection. Isn't she leading a witness, Your Honor?
She summarized some things that have already been said.
And she was on the phone talking to 911, correct?
Correct.
And did you hear her give the name of a perpetrator?
Yes.
And what name did she give?
She said Senator Virgil Smith.
At that point, did you take the phone from her?
Yes.
And at that point, did you put her out of your house?
Yes, I did.
You are a friend of his, not hers, right?
Correct.
Now, she was attempting to get help, correct?
Objection.
I don't know.
Okay. She was calling the police, certainly you understood that, correct?
Objection. There's no calling of the police. The objection to call to 911. That's not the police.
Who is it?
911 is a 911 officer who receives calls for 911. They're not necessarily connected with the Detroit Police Department.
She didn't say what police department either, did she?
No.
All right. Okay.
Okay, thank you.
Well, Ms. Lindsay?
Yes.
He did not say the police.
Okay. She did not say the police. But, sir, in your general experience and common sense, when you call 911, are you calling for Domino's Pizza Delivery?
Argumentative. Objection. Argumentative, Judge.
You wanted to make a distinction as to what 911 is, and she can go into it. That was your objection, so she can go into it and clear it up.
Under your common understanding, common sense, and general knowledge, when you call 911, are you generally calling for the police?
Or fire, or ambulance, or anything that's been called.
You're calling for assistance and help, correct?
Sure.
Thank you. And when she was calling for assistance and help, you took the phone from her.
Yes.
And you put her out.
Yes.
Okay. After you put her out, do you see Virgil Smith?
Yes.
And where do you see him at?
About another 20 minutes or so, he came knocking on the door.
He came knocking on the door.
Yes.
And at that point in time, did he ask you for some help?
Yes.
He said, I need your help.
Yes.
And when he said, I need your help, you went down to his house. Is that correct?
Yes.
Did he tell you, strike that. You went down to his house, correct?
Yes.
Did you see Anistia's car?
Yes.
Had you had any knowledge about the state of Anistia's car before you went down to Virgil's house?
Yes.
Ms. Lindsay,
Excuse me, Mr. Smith's house.
thank you.
I'm sorry, Judge. And did you look at her car?
Yeah, I glanced out.
Could you tell whether there were bullet holes in the car?
Yes, there were holes in the car.
Approximately how many did you see?
Hood, windshield, fender, maybe four.
Did Mr. Smith tell you how those holes got in the car?
No.
Did you ask him how those holes got in the car?
No.
So if I get this straight, Anistia comes to your house, uses his phone, calls 911, you put her out, you have some information about something going on with the car. When you saw the car, did that confirm the information you had about what happened to the car?
No.
Didn't you have the information that there were bullet holes in the car?
My
Okay, when you looked at the car, did you see what
Holes
appeared to
in
be
the car
bullet?
that she said, yeah. I
Did
saw
you-
the holes that she said she saw.
You have to let me finish that.
Oh, sorry.
Did it appear to be bullet holes in the car?
They could have, yeah.
Okay. And you're telling us that you didn't even once say, ma'am, what happened to the car?
Nope.
Okay. You didn't want to know?
Nope.
Okay. But you were there to help, correct?
Yes.
Did you see any shell casings?
No.
What do you do when you go to Mr. Smith's house?
Jackson, what's the relevancy of going to Mr. Smith's house unless it's connected to some extent by this event?
This is what we're talking about.
So
Your
it's
Honor.
just eyewitness, and
Yeah.
he is talking to someone who's charged with a crime. He can testify to what he did, because to prove a case, the people can go into evidence of preceding an incident, which might show some motive, what happened, and how the person acted afterwards, which might be consistent or inconsistent with something occurring. You can go into that. This is immediately after the event.
You have conversation with Mr. Smith, is that correct?
When he came down to my house, yes.
Okay. Did Mr. Smith ask you to call the police?
No.
Did he ask you for any help?
Yes.
Did he ask you for any type of assistance for any wounds he had or injuries?
No.
Did you see any wounds and injuries?
Wasn't looking. Did not notice.
Okay, so you spent a considerable amount of time with him that night, is that correct? At least, did you spend at least 10 to 15 minutes with him?
Anytime it took me to walk down there and escort Tachi out of the house safely and then back home, yeah, that could have been 15.
Okay, and during that whole period of time, did you see any injuries on Mr. Smith?
Wasn't looking, no.
So the answer to the question is no, correct?
Didn't notice.
You didn't notice any injuries, correct?
Right.
Did Mr. Smith complain of any injuries?
His leg,
What did he say about his leg?
nothing, just said it hurt, but I didn't see he had pants on.
Okay, and did you put that in your statement?
No.
Thank you. There was a woman in his house, is that correct? And what did Mr. Smith ask you to do as it relates to that woman?
He asked me to help him get Tatiana out the house because she was scared and wanted to leave the room.
At that point in time, did he ask you to call the police?
No.
Did you see Tatiana?
Yes.
In your presence, did she call the police?
I could not answer. I don't know.
In your presence, that means she's in your presence. Do you understand that?
No, she didn't say it in front of me.
Okay, so in your presence, she didn't call the police.
No, she just wanted to get out.
Okay. Did you see any shell casings?
No.
Did you remove any shell casings?
No.
Did you remove any gun?
No.
After you get Miss Tatiana out of the house, and by the way, do you know Tatiana?
Yes.
Okay. And you had met her previously?
Yes.
Had she been over to your house also?
Yes.
With Mr. Smith?
Yes.
Okay. And in terms of the amount of time you saw Tatiana and the amount of times you saw Miss Thomas, would they have been roughly about the same?
Yes.
Okay. At any point in time when you were with Mr. Smith that night, did he ever say, I need you to call the police?
No.
I have nothing further this witness.
Just a moment now. Now, when you testified that you saw Miss Thomas arrive at your front door, correct?
That's her last name. Ex-wife.
Yeah, Anicia, as you know it. Now, when you had a chance to look at her, right?
Yes.
Did she have blood all over her face?
No.
Did she have blood all over her clothes?
No.
Did you see whether or not her hands were scraped?
Yes.
Did you see her with any life-threatening injuries?
No.
Now, You had a chance to speak to her briefly, did you not?
Yes.
Did she ever say to you that Virgil Smith shot at me?
Objection, Your Honor. He has to lay a foundation, or else it's going to be hearsay off of the truth of the matter. So
I'll rephrase, Judge. You previously testified that you heard some gunshots.
Yes.
And you testified that Anicia came to your front door.
Yes.
And you had a brief conversation with her.
Yes.
And you were able to observe some of these, her lip being busted. Is that all that you saw, her lip being busted? It wasn't blood all over her face, was it?
No.
Okay. Now, as a result of that conversation, did you draw any conclusions about whether or not she had been shot at?
objection, Your Honor. That would be opinion evidence, and it would be speculation.
Well,
How does an injury show if a person's been shot at? Injury might show if a
I'll rephrase.
shot, but it certainly won't show if a person missed.
I'll rephrase it, to make it clear. You heard some shots.
Yes.
She arrived at your front door.
Yes.
And as a result of those shots that you heard, and her arriving at the front door, did you draw any conclusion as to whether or not those shots had anything to do with her?
Objection, Your Honor. What's the relevance of what his conclusion is about the shots?
Sir, whenever you hear objection, stop talking, okay? Do not answer. Counsel?
He testified.
No, he hears gunshots, and he draws a conclusion as to what occurred just by hearing gunshots?
Well, it's just not hearing gunshot. The young lady appears at his front door.
Okay.
The lady appears to have some injuries.
Okay.
And he
So
could
what
draw.
conclusion do you want him to draw from?
I don't know. That's why I want to ask him.
How would that not be speculation?
It is speculative. How can, if I hear gunshots outside my door and someone comes by, that's all I know. And that's all I can testify to. Not to what conclusions I draw from it.
Mr. Smith, did you have any discussion with Anicia about the gunshots?
No.
Now, you say that you had a chance to go down to Mr. Smith's house, correct? And you said you had an opportunity to look at the car.
Yes.
And I think you indicated that you saw some holes in the car.
Yes.
And am I correct that in your statement you said that you saw gunshots in the hood of the car?
Yes.
You also saw gunshots in the window?
Yes.
And I think you also testified that you saw gunshots in the headlights. Yep. Quarter panel? Yes. Okay. Now, was anybody in the car at that time? Was Anicia Thomas anywhere in the vicinity of the car at the time that you looked at it?
No.
Now, you say that Mr. Smith asked you to give him some assistance.
Yes.
And am I correct in your testimony that the assistance he wanted you to give was to assist him from getting Tatiana out of his house?
Yes.
And is that what you did?
Yes.
And did he tell you why you needed to help him get Tatiana out of the house?
Your Honor, this would be, he can't get his own client's submissions in under the rules of evidence.
Must be a part of your opponent, counsel.
Now, Judge, I believe he already testified to that on direct as a result of a question from direct. That he needed to help to get Tatiana out of the house because she was scared.
Okay. So what are you asking?
Well, I just want to, that door has been open.
No, what I
Okay, all right, I'll ask the question.
Because, go ahead, ask the question and we'll make a determination if it is
Okay.
something that can be answered. Counsel, sir, do not answer the question until I hear the question.
Okay, all right. What was the purpose for you assisting Mr. Smith?
Your Honor, what was the purpose? That would be speculation as to what was in his mind. When I say his, I mean the defendant's mind.
I'm not asking about the defendant. I'm asking him what was his purpose for assisting Mr. Smith. Madam Prosecutor opened this area of questioning. I'm just simply asking what is his understanding of what was his purpose. He can testify as to his belief, and she opened this area.
And why is his belief relevant?
It's relevant because you asked, the prosecutor asked him, did Mr. Smith ask you to give assistance?
I'll hear it.
Can you ask again?
What was your purpose for? What was the in your mind? What was the purpose or reason for you giving assistance to Mr. Smith?
Tatiana would not leave the house because he asked and he wanted me to come down there and help get her escort out because she was scared to step out.
Objection, that portion, because she was scared to step out, would be speculation on his part. It would be hearsay offered by the defendant for the truth of the matter asserted.
But the judge, you can hear that and judge the weight of that. It's his opinion.
No, I can only judge the weight of something that is admissible. If it is inadmissible hearsay, I can't judge the weight of it because it can't come in.
Well,
He can't testify to what is in someone else's mind. He's saying he's assisting because Tatiana was afraid. Now, how does he get to that?
he gets to there as a result of a conversation that he had with Mr. Smith, and as a result of that conversation, well, but I'm not asking him what the conversation with Mr. Smith is.
But counsel, you can't just ask a question and have someone draw a conclusion, which is in someone else's mind, because he had in the mind of Tatiana, because he had a conversation with Mr. Smith. How can he do that?
Well, Judge, I'm not really offering it for the truth of the matter. It's to judge.
No, you can't come in. You can't talk to Mr. Smith to find out what is in the mind of Miss Tatiana. I don't know her last name. What's her last name? I'm sorry.
Grant.
Miss Tatiana. He can't. Mr. Smith cannot testify or tell Mr. Cade what is in the mind of Miss Tatiana Grant.
Okay, Mr. Cade, please tell us what you in fact did when you went to the house.
Went in, talked to her through the door, told her that everything was clear, that Anicia was not in the area. I would walk her to her car.
Did you walk her to the car?
Yes, I did.
Did you assist her into the car?
I just opened the garage door and she got in the car.
Did you have any impressions about her condition at that time?
No.
Did you open the garage door up?
Yes.
Where was your car located?
In the garage.
Could you see her car from outside looking into the garage?
No.
So let me make sure the record is clear on this. You had a conversation with Mr. Smith
Yes.
requesting assistance.
Asked and answered. I mean, at this point, he's been over that ground.
All right, Judge, I'll move on from that. Now, you were living with another young lady at that time, were you not?
Objection, Your Honor, is to relevance.
Well,
Why is that relevant for a probable cause hearing?
well, it's relevant because this witness was present in the house at the same time Mr. Cade was, and this witness had the encounter with the complaining witness at the same time that Mr. Cade, and I'm going to call this witness on my case.
Well, first and foremost, why is it relevant if he's living with anyone? You can ask whoever's present. If it's a racist situation, you can ask that question. How is it relevant if they're living together right now?
All right. Did you observe, who is Shanta Grant?
My girlfriend.
Okay. Was she present in the home?
Yes.
Was she present when Miss Thomas came to the house?
Yes.
Was she present when discussions were had with Miss Thomas?
Yes.
Did it come the time that she left the house?
Yes.
Did it come a time that she came back to the house?
Yes.
Now, do you recall her having a conversation with Miss Thomas?
Yes.
At that time, did you recall Miss Thomas telling her?
Objection, Your Honor. Hearsay. Can we go approach so you won't put anything on the record that should be
I'll
on the
withdraw
record?
that, Judge. Did you hear the conversation between Miss Thomas and your girlfriend Shanta?
Objection as to relevance, whether he overheard a conversation, is not foundational for impeachment.
Okay. Madam Prosecutor, at this point, he can ask that question. He hasn't gone anything other to hearsay. He could be laying foundation for something. I don't know.
Okay.
But certainly he has not asked anything at this point that would be asking for something that would be inadmissible.
Did you personally draw any conclusion about that conversation?
Objection as to relevance. What his conclusion is about any conversation anybody has with anything, how is that relevant to a probable cause determination about whether this man committed any crime?
How is that relevant? If
Well,
two people have a conversation and you ask,
I'll
what
rephrase.
conclusion did you draw from that?
I'll rephrase it, Judge.
Your Honor, there's no rephrasing that. Anything he's
I'll
seeking
rephrase
in that area is inadmissible.
I would have to hear how he rephrases it. Maybe going someplace else. I don't know.
I'll go to another area. You had a chance to see Mr. Smith on that night, correct? Okay, was he drunk?
Your Honor, I'm going to object as to how he can make that conclusion, how he can make that assessment.
Well, counsel, I think with our common sense reasoning, we can look at someone and make a determination. There comes levels. There are some people that you might see that may be falling out drunk, and you can make a common sense assessment. Sometimes you can tell, you observe or you smell intoxicating liquors, and you may make some assessment. That's something that we as rational people can do.
Okay, if he wants to open that door.
I have no idea where any of this is
Well,
going, but he can ask that question.
Just want to make clear that I won't say that. Okay. Did you smell alcohol on his breath?
No.
Did his eyes appear to be dilated?
No.
Did his eyes appear to be red?
No.
Was he stumbling around?
No.
Did you ever see Miss Thomas come down and attempt to drive the car? Did you ever attempt to drive the car? Did you see anybody attempt to drive the car?
Yes.
Who was that?
My girlfriend.
Okay. And you were present when that happened?
Yes.
Okay. Now, was that before Miss Thomas came to the door or after Miss Thomas came to the door? Now, when you say you were present when your girlfriend Shanta tried to drive the car, was Miss Thomas present? Was this before or after Shanta Grant came back to the house? Excuse me, your girlfriend came back to the house. Okay. I'm trying to make a determination if you were present at any time the car was driven or attempted to be driven.
Yes, I was at the house.
You were at the house.
Yes, I was at the house.
Okay. My question was at the car itself.
So that at the actual vehicle.
Yeah.
No.
Oh, okay. That clears it up for me. So you were not at the vehicle at the time it was attempted to be driven. And you did not personally see anybody attempt to drive?
No.
Your Honor, now I have everything stricken about him seeing his girlfriend trying to drive. I'll have it stricken because I'll ask it to be stricken.
I agree. I think he thought I was talking about.
I don't know what he thought.
Yeah, yeah.
Certainly, he indicated he did not have personal knowledge of anyone trying to move the car. So our references to Ms. Tatiana Grant attempting to drive the car would be struck from the record.
Thank you, Your Honor. When Ms. Thomas was at your house, did she make any complaints?
Objection, Your Honor. At this juncture, he's going to have to lay some type of foundation to get around the hearsay rule, which he has not done at this juncture.
I'll rephrase, Your Honor. Did you make references to what Anicia said to you in your statement to the police?
I'm sorry. Reverse. Yeah, ask you.
In your statement to the police, did you make references to what Anicia said to you?
Yes.
Objection, relevance. What relevance is that?
Well, I haven't asked another question.
Well, if you're going to ask a question about what Ms. Thomas said, because it's in the statement, does not make it admissible in court. So just because he may have said something, it still has to be admissible and relevant today. So you can ask your preliminary questions, you're laying your foundation, or whatever it is that you need to go where you plan to go. But at this point, asking if you have a conversation with her, certainly, and the fact that it's in the statement that court of law.
Okay. In your statement, you made some references to what Mr. Virgil Smith said to you, did you not?
Objection as to relevance. As it relates to what Mr. Virgil, first of all, since just because it's in the statement does not make it admissible. And second of all, under Michigan rules of evidence, it's submission by a party opponent, which means if I can put it in if I choose, he can't put it in his own client statement in.
Mr. Good?
All right, Your Honor. All right, Your Honor, I have nothing. I have nothing further, Your Honor.
Anything else, Mr.
Nothing further, Mr. Chairman.
Your witness is excused?
Yes, Your Honor.
Okay, you may step down, you're excused. You're free to go.
Who's next?
here, ma'am. Position that microphone so you're speaking directly into it. Thank you. Keep your voice strong. Your witness.
Ms. Thomas, good morning. I'm going to direct your attention back to the early morning hours of May 10th, 2015 at around 1 in the morning. Did you go to 18601 Wexford Street in the city of Detroit?
Yes.
And who did you know to live there?
Virgil Smith.
And what was your relationship with Mr. Smith?
He is my ex-husband.
Okay. And currently at the time of May 2015, had you guys resumed an intimate relationship?
Yes.
Now, tell me what happens once you get there.
When I get there,
Strike that. Let me back up a little bit. Had you two text back and forth all day?
yes.
And prior to you going there, was the last text that you sent to him something about you're really fucking up now or something of that nature?
Objection, that's leading, Your Honor. The direct statement as to what she said.
She asked, was that text? She didn't say your last text said this, did it?
I asked
It
what.
was a question. She can deny it. She can adopt it. She can say she doesn't remember. So it's not a leading question unless it suggests the answer. Because it's a direct question, does not make it leading.
And he did not respond to that text, is that correct?
Yes.
Yes, he did not respond.
Yes, he did not.
Okay. You went over to his house on Wexford Street, is that correct?
Yes.
Tell me what happens once you arrive at Wex. No, let me back up. I'm sorry, I'm getting a little ahead of myself. Were you driving a vehicle?
Yes.
Could you describe the vehicle you were driving?
It was my 2015 Mercedes-Benz GLA 250.
You arrive at his house in that car, is that correct?
Yes, that is correct.
Tell me what happens when you get there.
When I get there, I pull up behind his vehicle, which
And-
was
Where was his vehicle?
on the side of the street.
Okay. You pull up behind his vehicle, and then what happens next?
I pull up behind that. I get out.
And where do you go?
I went to his bedroom window because I noticed that it was open.
Okay. You went to this bedroom window, and what happens?
I knock on the window, and then I say Kai.
Do you know his name, middle name to be Kai, or?
I call him Kai.
Okay. Is that part of his name, though?
Yes, it's his middle name.
Okay. You always addressed him by his middle name.
Yes.
Okay. So you said Kai. What happens next?
Then he comes to the window.
Okay. And when he comes to the window, what happens? Do you have conversation through the window?
Yes. I noticed that he was.
Do you have conversation through the window?
Yes.
Okay. That's what I'm asking about. After you had conversation by the window, what happens next?
He meets me at the side door.
Okay, so you go around to the side door from the window.
Yes.
Okay. Does he meet you at the side door?
Yes.
What happens next?
He opens the door.
Okay, then what happens?
He lets me in.
What happens?
I'm walking through the hallway.
And how much distance is the hallway to the bedroom?
Maybe about 8 steps.
Okay. And why were you headed to the bedroom?
Because our routine is when I pull up over there, he always helps me out with getting my belongings out of the car.
No. I'm asking you, were you walking to the bedroom because that you were planning on having relations with him?
Yes, and spending the night. Yes.
Okay. What happens next?
He says the word Tatiana here.
He says Tatiana's here.
Yes.
Then what happens?
I walk into the bedroom.
Okay. Did you make some observations in the bedroom?
Yes, I do.
What are the observations you make?
I see Tatiana in the bed.
Okay. And some conversation ensue after that?
Yes, I went up to the bed.
And what happens when you go up to the bed?
I ask her if they are sleeping together.
Okay. Wasn't that obvious to you at that point?
No.
Okay. What did you do?
After I asked her if they were sleeping together, she sat up and she said no.
Objection as to what she said.
Okay, I wasn't asking her what she said, but she just said it.
Well, I asked her to be stricken as hearsay.
Oh, fine. I don't care.
No, we're right there.
Okay. So you go up to the bed, you have conversation with her. Do you take some action after that?
After she said no, and she asked Kai,
Ma'am,
told me
don't
to
tell
ask
me what
that.
she said. I'm asking specifically what action did you take after that?
Yes, I snatched the sheet off of her. Yes,
snatched
that's
the
the
sheet.
action.
Okay. You snatched the sheet off of her, and what did you see?
That she was naked.
Okay. And then what happens at that point?
At that point, Kai grabs me.
Okay. And what happens between you and Kai at this point?
We get into an altercation.
Let me stop you there. When you say Kai, do you see him seated in the courtroom anywhere today?
I do.
Indicate, could you point to him?
Right here.
Indicating for the record the witnesses identify the person of the defendant, Mr. Virgil Smith Jr. Okay. So what happened? You said you get into an altercation. What happens now?
From there, he pulls on me. We wrestle. He punches me in my face a few times.
So let me stop you. Is there a TV there?
There is, but he punches me in the face before we even encountered the TV.
Okay. So I'm going to get to that. So he punches you in the face. Are you standing? What happens?
We are standing and wrestling.
Okay.
Our hands engulfed in each other.
Does there ever come a point in time when you end up on the floor?
Yes.
Tell me about that.
After falling into the TV, he rams my head into the floor.
Okay. Okay, then what happens?
Then after that, he puts the back of his right arm into the back of my neck, and it basically stopped my breathing at that point.
Okay. Is he telling you to leave?
He is. He
Okay.
said he'll let me up
If you leave?
if I leave.
Okay. And do you say you'll leave?
Yes.
What happens next?
He kept punching me throughout my body at that point. I stumble up to leave.
Okay, so you're trying to get up to leave.
Trying to.
What happens?
He literally rams my head into the wall of the hallway. It's by the door, the hallway. My face hits the wall.
Okay. And do you get up?
I fall down.
Okay. Then what happens next?
Then he takes my arms again. He continues to force me and beats me down the hallway.
So down the hallway toward the door.
Towards the door.
Okay. And do you get out?
Yes, he opens the screen door and then pushes me out again.
Okay. And when you say pushes you out, when he pushes you out, do you fall?
I do. I fall over the railing and then my face hits the concrete.
Okay. So at this point, you're out of the house. Is that correct?
That is correct.
Okay. And does he go back in the house?
Yes, he
Okay.
does.
And when he goes back in the house, is your car still there?
Yes.
Okay. You don't go to your car and leave, do you?
No.
Okay. What do you do?
I go to the front of the house.
You go to the front of the house, and what happens at this point in time?
I pick up a wicker chair.
You pick up a wicker chair.
I threw it up in the air.
Okay.
And it hit the porch back
Okay.
down.
At the point in time you threw the wicker chair, it hit the porch. He was on the inside?
He comes right out. I hear him coming
Ma'am,
out. Yes.
listen to me. At the point in time you threw the chair, and it hit whatever it hit, he was on the inside.
Yes.
Okay. Now, what happened? And you're still on the outside of the house?
Yes.
Okay. What happens now?
He comes out on the side from the side door.
He comes out from the side door, and could you see anything in his hands?
Yes, because I come to the side.
Okay. When you come to the side, what is it that you see?
I see him holding a big gun.
Okay.
In the air.
You saw him holding a big gun in the air. Was it a long gun?
Yes.
Had you seen that gun previously?
Yes.
Okay. And what did he tell you? Had he shown you that gun previously?
Yes.
And what did he tell you about that gun previously?
That it was an AR-15. He showed me where it was, where he kept it.
Where did he keep the AR-15?
Under the bed.
Okay, he kept the AR-15 under the bed, and he told you that it was an AR-15. Is that correct?
Yes.
Did he tell you anything about the power of that gun?
Yes, it was an assault weapon, that it could pierce through houses. It could take off someone's limb, arm.
Okay. So he comes out with that AR-15, or what he has described to you as AR-15. Is that correct?
Yes.
And what, if anything, does he do at that point?
He starts shooting in the air.
First of all, he shoots it in the air, correct?
Yes.
Okay. And when he shoots it in the air, does he do anything after he shoots it in the air?
Yes, he turns it towards me and starts shooting at me.
He turns it towards you,
Yes.
correct?
Yes.
At that point, do you start to run?
I do.
Okay. And where do you run?
I run next door.
Okay, you run to the next door.
Yes.
And do you still hear shooting?
Not after he shot at me. No. No more shots.
Okay, you didn't hear anymore.
No more.
Okay. question is, you didn't hear anymore.
No, I did not hear anymore.
Okay. Now, what do?
I run to the backyard to hide
Okay, and why is it you're running to hide?
because I could hear his footsteps and his voice coming closer.
Okay. Now, do you eventually make it down to Carlos Cade's house?
Yes, I run in and out down the street.
Okay. And you know Carlos Cade through the defendant, is that correct?
Yes, they are friends.
Okay. And what happens when you get to that house?
I bang on the door. Him and Chance come to the door.
Hold on.
Excuse me. Sorry. Where is it? It'll stop in a minute. Wait a minute. Where is it? Sorry about that, Judge. Sorry about that, Judge.
Thank you. So you knocked on the door of Carlos Cade.
Yes.
You had met him previously.
Yes.
Okay. And let me just ask you, Tatiana Grant, did you know her previously?
Yes.
Okay. Now you get to Mr. Cade's house. At that point in time, what happens?
Him and Chance open the door.
Do you go in?
I do.
Okay. And do you go to clean yourself up?
Yes.
Okay. At some point in time, while you're at Carlos Cade's house, do you retrieve a cell phone, or do you get a cell phone?
Chance's cell phone, yes.
Okay. And what was your purpose for getting that cell phone?
Calling 911.
Okay. And when you were calling 911, were you calling 911 in Mr. Cade's presence?
Yes.
Okay. What happens when you start to tell 911 what was going on?
Mr. Cade snatches the phone from me and hangs up the phone on 911.
Okay. And then at that point, were you allowed to stay in the house?
No, he pushes me out and locks the door.
Okay. And he pushes you out and locks the door. And previous to that, did you ask his girlfriend to go get your car?
Yes, I did.
Okay. Did you give her the keys?
Yes.
Okay. Did she come back to the Cade house?
Yes, she did.
And when she came back, did she have your car with you?
No.
With her. Okay. Now, they put you out. When you're outside now, do you look and do you see Mr. Smith?
Yes, I do.
And where do you see Mr. Smith at?
On the sidewalk.
Okay. And what do you do at that point in time?
I start walking down across side street, away from him.
You start walking away from him. And do you make it to some place else where there's some people?
Yes, I do.
Okay. Now, the house that you made it to, did you know these people?
No.
Okay. Did they allow you in?
Yes.
And did they keep you there and allow you to call 911?
Yes.
Okay. Now, the police come, is that correct, eventually?
Yes, they do.
And the police escort you back to Mr. Smith's house where your car is that correct?
Yes.
Okay. Did you see the state of your car now?
Yes.
Could you tell me about the state of your car?
Multiple bullets in the car.
Bullet holes?
Bullet holes. There were bullets on the floor.
In the car?
In the car.
Okay.
Busted, shot through windshield glass. There were shots in the hood of the car and the headlights.
Okay. Were you able to, at that time, retrieve your cell phone from the car?
Yes.
Okay. Is that why you had to use Mr. Cade's cell phone and the stranger's phone because you had left your phone in the car?
Yes.
Nothing further, this witness.
All right. Okay. Good morning, Ms. Thomas.
Good morning.
Let me ask you, you normally communicate with Mr. Smith by text or telephone, isn't that correct?
Both.
Both, okay. And am I correct that your telephone number is 6?
We can't, let's not put it on the record.
You can show us something.
I will stipulate to whatever the text messages.
You stipulate to the
Yeah.
Okay, good, okay. Okay. Thomas, you first, let me ask you this. You turned your phone over to the Detroit Police Department, did you not?
Yes.
For them to what is commonly called
Your Honor, we'll stipulate that she turned her phone over for them to do her forensic exam, which is commonly referred to as a cell phone dump.
Okay. Would you stipulate, Madam Prosecutor, as to the text messages that I want to make reference to?
Yes.
Okay. May I approach the witness, Your Honor, with the relevant text message? And I'd like to give the court a copy of the relevant. I will be offering this as evidence so that the court can follow along. Okay, we'll have them marked. Okay. We call this exhibit number 1.
No, the court reporter marks.
Okay. Make sure I got all the pages. That and the telephone dump. May I approach the court would like a copy, or the court wants to look at you?
A copy is fine with you.
All right.
You want me to see it?
Yes, because I want you to follow along.
Very well.
That's the telephone dump, and this is the
Okay, now, the problem is, well, I'll figure it out. So you have the items marked, is that correct?
Yes, they're marked here. A and B.
All right.
Marked A.
Just so I understand, what is marked as A?
A is the text message dump to the relevant period of May 9th,
So,
pages 800 to 797.
4 pages, correct?
Correct.
And you say that's the
Text message
done.
dump.
All right, 4
And,
pages.
and then we have the
And it's
telephone.
marked as what?
A.
A.
And we have page 41, which is the telephone dump, and it's marked as Exhibit B.
Very well.
And I'd like to hand those to the witness, if I may. I'd like to hand you, first of all, Exhibit A.
Thank you.
Okay. Now, I've given you the, let's start with Exhibit A, which is the text message dump. Now, you previously testified on direct examination that it was your understanding that you were supposed to have sexual relations with Mr. Smith that evening.
Yeah, spend the night.
Okay. And you communicated that encounter through the text messages, did you not?
I know that we did verbally.
Okay, well, okay, so are you saying that on May 9th, in the morning of May 9th, 2015, that you met personally with Mr. Smith?
No, we didn't meet that morning.
Okay, so you text messaged him that morning, did you not?
Yes, and he called me.
Okay, all right, well, let's just start with the text messages before we get to the call. All right, Exhibit A. Now, if you would look at note number 338 on page 800. Okay? Now, in that message, you're texting to Mr. Smith at approximately 7:27 in the morning. Is that correct?
Your Honor, let's have the times because we have to use it as UTC minus 4. I mean, the whole time.
Okay, I'll do that. 7:27 and 39 seconds a.m. UTC 4.
Minus 4.
Minus 4. Or hyphen, whatever. Is it minus 4? Is fine.
Minus 4.
Okay, minus 4. Right?
Yes.
Okay. And you say to him, Are you going to the Jeff Jack dinner? Are you going to the Jeff Jack dinner? Jeff.
You have to read it as it is printed on the page. That's not Jack, it's Jeff.
Oh, okay. Are you going to the Jeff Jack dinner? Did you that you meant to say the Democratic Party's Jefferson Jack dinner, right?
Yes.
So that was a misspelling on your part in the text, correct?
Yes.
Okay. Now, and he tells you no, right?
Your Honor, I'm going to object. If he's reading from, he's using this exhibit to put the text messages in.
Right.
The exhibit on the text message does not say that. He has to do it from the text message.
I stand corrected. Look at note 333. From Mr. Smith. That's May 9th, 2015 at 8:24:55 a.m. UTC -4 from K. Smith Virgil. And he says no, right? Now, after the conversation about the Jefferson Jack dinner, you have a discussion about Ms. Talib looking at note 326. Now, this message is sent by you to Mr. Smith. 5/9/2015 at 8:30:15 a.m.
Counsel, I got to say this because you're jumping all over the text messages with a response and we don't even know what the question is. I don't know how to take that in context.
Okay.
The last question you asked about the dinner and the answer was no, but I don't even know what the previous question was. The question prior to that is it even a dinner this year? There's no info on it.
Okay.
And the answer was no. But if you just give me an answer to a one-liner to a question, I mean, the answer to a question, I don't know what the question is. There is no context in which I can look at it and draw and make any assessment of what we're doing.
Okay, Judge, I apologize that what I was attempting trying to do is to limit the number of text messages we had to go. I understand that now. I understand it. So I will go step by step. I tried to for judicial economy, but okay. All right, let's go back to 338.
Your Honor, at this juncture, I'm going to object as to specific relevance, as to specific. He has a point he's trying to make or he wants us to put out.
Yeah.
I have no objection to him pointing out a specific text message. I have no objection of him making a point. But to read all the text messages that they had during that day is simply not relevant.
And that's what I was trying to avoid.
Except that you were giving me an answer of no.
Okay.
I don't know what the no is
I
too,
understand.
so that doesn't help me at all.
All right, I'll get.
Something specific you want to go into?
I agree to that. I will agree to that. Now, I want you to look at note number 319 and note 313. These are messages from Mr. Smith. Okay? I want you, now, between 313 and 319, isn't it true that you sent a text message that you erased from your telephone between those two calls?
I don't remember.
Okay.
Your Honor,
Between those two calls.
Your Honor,
Bet-
at this juncture, if he has evidence, he has not shared it with me,
I'll do that.
which is one of the things we talked about earlier.
Counsel, first off, if you want to go into something, you either want to impeach this witness or you want to do something of that nature, first you have to ask the question that you want to go into. Then if you have something to suggest that answer is not honest or truthful, and you have something that you can use to impeach the witness with, then you have to do that. But you have to start with a question to the witness first and foremost.
And additionally, anything he's going to use that have not been authenticated, I object to. The cell phone don't have been authenticated because it's a forensic cell phone don't. If he is going to attempt to use anything from Mr. Virgil Smith's phone that has not been authenticated, I'm going to object because there's no way for us to tell it is what it purports to be. Plus, he didn't share that beforehand. So unless he can get over the hurdle of authentication.
First of all, just let me know where you're going first, because I have no idea.
Okay, okay. What, Your Honor, we have a situation here where it is based on looking at the telephone, the cell phone of Mr. Smith and comparing the text dump. The entries are exactly the same, have the exact same information, exact same time, except that there is one communication from this witness that is not present. And we want to impeach her because it is our position, and I wanted to ask her, did she erase that message from the cell phone prior to turning over the phone to the police?
Well, and once again, anything he's using that comes from Mr. Virgil Smith's cell phone is not properly authenticated. I would object. Furthermore, we have been in communication for the last couple of weeks. He did not put me on notice that he was using anything like that. I would object. No authentication, not supplied to me in discovery.
Well, there's a couple of things that's going on. First, you indicated that you want to impeach with a statement. One, there is facts not in evidence. Certainly, if there is something, as the prosecution has indicated, that can be authenticated, because one, the cell phone dump that I have here, I certainly don't know, because we don't have an expert to testify today, that all the information, even if I delete something off my telephone, does that delete it off the records that would come from the source, if it be Verizon or Sprint or whatever? I don't know that. Just deleting it off my phone would actually delete a record that is a computerized record with the company. So certainly, if it's not on here, I don't know that any individual person can affect that. And two, if you have a phone that is showing something different, I don't know where it came from, how it come from. If in fact there can be some type of glitches in the system where I text someone, they don't get it, or it shows up in one place and not the other. These are all matters. These are things that, one, is a reason that if discovery is mutual, these things can be shared and they can be checked out and verified or what have you. But certainly to pull out a phone now and say that there's information on that phone that is inconsistent with a forensic dump, a forensic examination of Miss Smith's telephone, as opposed to I'm just going to hand you my phone and I don't know how the information arrives on it. I don't know what you're asking me to do, counsel.
Okay, I'm just going to ask her a specific question,
Your Honor,
and we can tie it up later on at another time.
You can't. First of all, it has to be legally admissible at this point. Anything he has in that cell phone is not legally admissible because it has not been authenticated.
Well,
hold on a second. Let me respond. That is absolutely correct, Ms. Williams. You can ask the question, did you delete any information? He cannot impeach now with something that is not admissible, but he can ask her the question.
okay. All right, Ms. Thomas, on May 9th at 8 a.m. and 9 seconds, did you text Mr. Smith with the following statement? Definitely want you to dick me down today and tonight. Did you do that? Did you make that text message?
Yes.
Did you erase that text message from your cell phone?
Yes.
Prior to delivering it to the police?
Yes.
You destroyed evidence, did you?
No.
Now, let's go back to the text messages. Now, the last time you communicated with Mr. Smith on that day, was at 8:34 p.m. Note 232. And that note would be on page 798.
No, we talked after that.
Okay.
Not the last communication.
Okay. So but my question is that the last communication that you got from Mr. Smith?
Also, she said they talked, they didn't text.
Okay. That's the last text that you got from Mr. Smith.
What line are you on?
You texted him note 232 on page 798 at 8:34 p.m. 35 seconds p.m. UTC -4. You text to Mr. Smith, quote, "I hit you up." And I'm asking you, is that the last text message?
Yeah, to speed it up, Judge, I just
Yeah.
want to show you exactly where it was.
From what I see, yes.
That's the last text communication that you sent to Mr. Smith, correct?
Yes.
But you sent him another text message at 10:22:34 p.m. and that's note 230 on page 797 at the bottom of the page.
Yes.
You never received a follow-up text from Mr. Smith, did you?
Can we have what?
Page, okay.
Can we have what the message
Okay,
is?
yeah. The message 5/9/2015, 10 p.m. 22. That would be 2:30 on page 797. It's at the bottom of the page. The bottom of the page. 10/22/34 p.m. UTC -4 to Virgil K. Smith. To K. Smith Virgil. Call me when you on the way home. I will meet you there. Okay. Did you receive any text message from Mr. Smith after that?
No.
Okay. Now, you are, however, sent a final text message to him, and that's 228, page 797 again, at 12:15:19 a.m. in the morning, 5/10/2015, 12:15:19 a.m. in the morning. You sent the message to him saying, "You are fucking up."
Yes.
Now, were you at the house when you said that?
No.
Okay. You were not at the house when you said that?
No.
Now, you sent.
When you say house counsel, what house are you referring to?
Were you at Virgil Smith's house when you sent that text message?
No.
12:15, right?
Yes.
Now, are you sure about that?
I am sure I was not at the house.
Okay. Now, you sent one other message relevant to this evening, and that was message number 217, right above the going up there on page 797 at 5/10/2015 at 7 a.m. 6 seconds a.m. UTC -4
Okay.
to a Mr. Wilson Perry, didn't you?
I'm going to object as to anything going to anybody else.
Well, if you go on and see, it makes reference to what she says about Miss Tatiana Grant, the lady that's in the bedroom. Fine, I'll deal with it later, Judge. I'll deal with it later, Judge. All right, Judge, I'll deal with it later. Now, let's go to the telephone dump. You said that you called him, right?
When you're referencing when I called him, when are you referencing?
On the day of May 9th, 2015. You called him. Let's look at Exhibit B. You said that you We just discussed the text messages, correct? And now we're going to talk about the telephone call. Page 41. The May 9th calls start at number 29, and it goes backwards to 25. The calls that you made from your cell phone. Number 29, you made a call to Shatiana Gatson, right? I'll rephrase that.
We will stipulate to save time that there are no call activity between her and Virgil Smith on that day.
Thank you, Your Honor.
Reflected in the cell phone dump.
Well, I don't, what I see stops at 6:50.
We're just, the telephone dump, Judge, only goes to what occurred on May 9th. The time period in which the witness says that outside the text messages, she called Mr. Smith and made arrangements.
I heard her say she called on the phone. I didn't hear her say she called.
Did you telephone Mr. Smith on May 9th?
Yes.
On what phone?
On my cell phone.
You called him.
We called each other throughout the day.
Okay. I'm asking on May 9th, you called him.
Yes.
And you're looking at the telephone dump.
This telephone dump does not show the actual activity between Virgil Smith and I.
Okay. So you're saying the Detroit Police Department Computer Forensic Department's dump is in error?
Objection.
No.
Question argumentative.
What she said was it doesn't reflect on the counsel. She can't testify to the qualifications, procedures, or anything else that anybody else has done. She said it doesn't reflect on it. That's all she can testify to.
Do you have any evidence to establish that you called Mr. Smith on May 9th?
There's phone records, yes.
Whose phone records?
Current phone records that I have.
Related to what phone?
My cell phone.
This phone that we're talking about here?
My cell phone, yes. To his 207 number.
Okay. All right. Now, okay. Just a moment, Judge. I gotta make sure I got all my pages. Sorry for the confusion, Your Honor. Okay, now I got it. Okay, now let's go to the house. You arrived at the house at approximately what time?
I arrived after midnight. Don't know the exact time.
Now, there is a pattern to where you park your car when you come to visit Mr. Smith, isn't there? And that is in the garage, correct?
The pattern is on the side first.
And then you move to the garage.
Virgil moved my car to the garage.
Okay. But at some point, your car ends up in the garage.
Yes.
And Virgil's car remains outside. Is that correct?
That's correct.
Now, when you arrived at approximately midnight, you noticed, did you not, that Virgil's car was on the street?
Yes.
And you had previously indicated that you were coming there for the purpose of having sex, right?
Spending the
Pardon me?
Spending the night. That was our routine.
You're still denying the. You said that you. All right. Pardon me? Okay, you arrive at the house, right? And you notice that his car is sitting outside. Isn't that correct? Now, normally he parks his car inside, doesn't he?
No.
Okay.
Not when I'm spending the night, no.
Okay.
Because he has a van in the garage.
Okay. So, you didn't go to the front door, did you?
No, we never opened the front door.
Okay. You went to the window.
Yes.
And you knew that that window was his bedroom.
Yes.
Now, I assume when you normally visit him at night, you normally go and knock on the window, don't you?
No.
Okay. But on this occasion, you knocked on the window.
Yes.
Now, and this was after you had text that he was fucking up, right?
Yes.
So you suspected that there was another woman there, correct?
No.
Okay. Now, is it correct that you did not, I want you to hear me clearly, you did not bang on the window, right?
No.
Okay. You did not scream obscenities.
No.
You did not threaten to kill the bitch.
No.
Just so we can make this record very, very clear, you're asking a question in the negative, and the response is negative, which actually creates two negative or positive. These things he said, is it correct what he's saying? When he said you did not scream obscenity, is that correct?
That is correct. Yes, Your Honor. Thank you.
I just want to make the record clear.
Okay.
You can be saying no, I didn't say that, or no, I didn't, and I don't know. I'm sorry, sir, I didn't mean to interrupt your flow. I just want to make the record clear.
And Judge, I just want to make clear, I'm going to tie this up
No,
with the other witness.
I'm not
Okay.
trying to
Okay. Now,
your direction or anything like that. It's just that a person can be saying, no, that didn't happen, or no, that's not true. So when they just say no to a question that is negative in the first place. So.
I'll make it clear. Did you say, I'm going to kill that bitch?
No.
Did,
I did not.
did you say that you're going to fuck that bitch up?
No.
Okay.
Your Honor, at this juncture, I want to approach and see, because in order to ask these questions, you have to have a good faith basis to ask these questions.
Well, they could
And-
be a good faith basis. That could be communication with his client. So.
Well, then the only way it can come in is through his client
No,
at this
he
juncture.
can ask the question.
Okay.
Did she say that? He
Okay.
can do that.
Okay. I want to show you a photograph of the side of the house and see if that reasonably reflects the side of Virgil Smith's house.
Yes, it does. That's the side.
You can have that mark, sir.
May I approach the bench like that?
Well, you didn't ask if it's being admitted, if there's objection.
Well, I'm just
you can
asking.
publish it, so.
Okay. All right.
If there's no objection from the people, I'll see it.
No objection.
Now, in looking at this photo, would I be correct that the two windows to the left, the second window to the left of the front door is the bedroom door?
Well, I
Bedroom.
need some understanding of what I'm looking at. I see a
Okay,
door. Is
all
that
right.
the front
It-
door, is that a side
okay,
door?
is this the side door of Mr. Smith's house?
Yes.
Is this the side of the house that you first approached when you arrived on the evening or early morning of May 10th?
Yes.
And looking at, and does this picture reflect how the house looks on the side?
Yes.
Okay. And the second window to the left, is not that the bedroom window?
From this picture, the furthest window to the left is the bedroom.
Okay. Now, that's the window that you banged on, didn't you?
I did not bang on the window.
Okay. That's the window that you first went to.
Yes.
And that's the bedroom of Virgil Smith.
Yes, it is.
Because you've been in the bedroom.
Yes, I have.
Okay. Now, Now, so the first contact that you had with Mr. Smith on that morning was at this bedroom window.
Yes.
And you went up to it and called him out, right? Or called him.
I called his name.
Okay. Now, isn't it true that you opened that window?
No.
Isn't it true that you attempted to enter the window?
No.
Okay, now let's go to the second contact that you had with Mr. Smith. Now, let me back up a minute. I'll go for it. The second contact. This is when you went to the side door, right?
Yes.
And that's the door that's reflected in Defendant's Exhibit C, correct?
Yes.
And it has a metal gate on it in front of the door, doesn't it?
It has a metal screen door.
Right. And then it has an interior door, right?
Yes, it does.
Okay. Now, so you go to the side door, and Mr. Smith just appears at the side door?
Yes, he opens the door.
Okay. And you pushed your way through, didn't you?
No, I did not.
You did not. You did not push your way through the door?
No, I did not.
You did not think there was a woman in the house?
No, I did not.
You did not run to the bedroom?
No, I did not.
You did not run into the bedroom and attempt to attack the young lady in the bed?
No, I did not.
You did not approach the woman in the bed and yank the clothes, the cover off of her off the bed?
I yanked the cover off of her.
And to expose her naked?
I did do that, yes.
Why did you do that?
Because she told me she wasn't sleeping with him, and I did not believe her.
She told you that she was not sleeping with him.
Yes, she did.
But once you saw her naked, did you draw any conclusion as to her truthfulness or not?
I did.
Okay. And you thought she was sleeping with him.
Yes, I did.
And you became angry.
I was upset.
And you attacked her.
No, I did not.
Did you not force her up into the corner of the bed?
No.
Now, while all of this is happening, I assume Mr. Smith was following you.
No. At that point, Mr. Smith was attacking me.
Okay, so you go first through the door past Mr. Smith, correct?
Okay, Judge. Objection, asked and answered, repetitive.
No, I'm trying to establish the location of Mr. Smith now.
That's not what he started back with her actions.
I understand.
This court is a very intelligent court. I think the court can catch the testimony first time.
I did hear your questions and her answers.
Okay. Now, when you came through the door, you did not stop and have a conversation with Mr. Smith, did you?
Yes.
Okay. And you're saying that Mr. Smith just invited you in?
He let me in. Yes, he did.
Oh, he let you in. When you say let you in, that means he opened the door.
He opened both doors.
And you stepped in.
Yes.
Okay. Did he say, come in, please?
He said, Tatiana's here.
Okay. And then you stepped through the door.
I was already inside already.
All right, and you went past him.
I was already past him.
Okay, so you.
Counsel,
Okay.
you have to let her answer.
All right. So you were already past him.
I was already walking in the house before he said anything.
Okay. All right. I'm just trying to get the location. He opens the door. You walk past him. He's behind you. And
Yes, hold it, man. You have to say yes.
Yes, I'm sorry.
he's behind you.
Yes.
You didn't go into the living room, did you?
No.
You didn't go into the kitchen, did you?
No.
You didn't go upstairs, did you?
No.
You went to the bedroom.
Yes.
And you were running.
No.
Okay. And you ran in, you
Counsel,
walked.
she's answered that question 3 times.
Okay. So you're in the bedroom now.
Yes.
Mr. Smith is behind you.
Yes.
And in fact, after you had the conversation with the lady in the bed is when he grabbed you.
Yes.
And that was after you had pulled the cover back off of the young lady and exposed her as naked.
Yes.
He grabbed you from behind
Yes.
and pulled you back.
Turn me over.
Okay, he pulled you back.
Your Honor, I'm going to object. She gave the
She
answer.
gave the answer. You cannot change her answer.
He turned you over. He was attempting to remove you from the bedroom, was he not?
Yes.
Because he had not given you permission to enter the bedroom, had he?
That's true.
Oh, he gave you permission to enter the bedroom with another woman in the bed naked?
He let me in the house.
My question, did he give you permission to go into the bedroom where another woman was naked in his bed?
He did not stop me.
He did not stop you?
No.
Okay. He grabbed you then.
He didn't grab me at all.
Oh.
He didn't make any attempts to stop me.
All the time that you were in the bedroom, he made no attempt to stop you?
Objection. That was the mischaracterization.
That was not the question. And the answer she gave to a different question.
Did he grab you in the bedroom?
He grabbed me after I yanked the sheet off of Tatiana.
And he pulled you backwards?
Objection. That's a mischaracterization of what she said. She said she turned him around. Counsel cannot change the answers to the questions.
Counsel already indicated that. She gives an answer. You can't change her answer. You can ask questions. Her answers are her answers. If you like it or not, it is her answers.
A struggle ensued.
Yes.
You in fact fell over the TV.
Yes. We both did.
Because he was attempting to remove you from the bedroom.
He had punched me after that.
I'm just answer my question, please. Because he was attempting to remove you from the bedroom.
Yes.
Because you did not want to leave the bedroom on your own.
No.
You wanted.
That did not occur, or you did not ask question again, counsel, because I don't understand that.
You could have left that bedroom immediately when you saw that young lady in the bed. Could you have?
No, I could not.
Who was stopping you from leaving the bedroom?
Virgil.
So you're now saying that Virgil Smith is restricting you from leaving the bedroom.
He had me completely controlled, so yes.
Completely controlled.
I could not walk away. He had my legs. He also had my arms.
And that's because.
Excuse me 1 second. Ladies and gentlemen, listen. Someone. Ladies and gentlemen, this is a court of law. This is not a source of entertainment. Anybody who has anything to say, makes any reference, comments, laughs, leave. This is serious. This is not something for your entertainment. So if you cannot maintain sense of decorum, then leave. If you do it again, you will be removed. I apologize, Mr. Stewart.
Okay. I'd like for you to see if you recognize this photo.
Yeah, that's his bed.
Okay. I'd like to have that marked, please. I'm going to ask.
the way
I think she can test. She said she recognized that I will lay foundation if the court would allow me.
Judge, this is a probable cause conference. Probable cause hearing. The state of the bed has nothing to do with the gunshots in the car. That happened outside. What does a picture of the bed have to do with anything determining probable cause?
It has to do with establishing, impeaching this witness as to whether she's been testifying that she was being restricted from leaving the bedroom. She's testifying that that Mr. Smith voluntarily allowed her in the bedroom.
So how is a picture of the bed going to indicate anything?
I'll bring it in and get something with someone with my other witness.
No, because I don't care what witness it is. If it has no evidentiary value, it does not come in.
It has the evidentiary value, Your Honor, and shows that she destroyed the bed attempting to attack the young lady.
Destroyed the bed?
Yes, she ripped the sheets off the bed, ripped the
So you're going to have someone come in and say, I took a picture at some time later, and this is the way that this witness left it, and that person was not there who took the picture.
No, I'm going to have the lady that was in the bedroom testify that this was the condition of the bed.
And even if it is, counsel, tell me how a person snatching the sheets off the bed has to do anything with a person producing a weapon and firing it. This is a probable cause hearing.
All right, Judge, I'll move on. Judge. I'll move on past the bedroom. Okay.
This is not a trial.
I understand, Judge. I'll move on past the bedroom. Now, just a couple more questions in that area, though. You fell over the TV, right? Both of you. You knocked the TV over, right?
We fell into the TV.
And you got a couple of injuries as a result of that falling over that TV, didn't you?
Several injuries.
From the TV, the struggle.
From a lot of the back, my back, yes.
From falling over the TV. Because it was metal.
Yes.
And both of you fell over the TV.
My back, I fell, he fell on top of me.
Okay. Pulling you away from the bed.
No, that was after he had punched me in the face.
Okay.
When we turned over into the TV.
Okay. Now, you bit Mr. Smith on the arm, didn't you?
No.
You bit him on the forearm, didn't you?
No.
You bit him on the wrist, did you not?
No.
He was bleeding, was he not?
No.
Okay. All right. After that event, he forces you out of the house, right?
He pushes me.
Out of the house. Okay. Now, you go outside.
Yes.
You fall outside onto the grass.
No, I fall onto the concrete.
Okay. Isn't there grass right below the railing?
There are two sides. There's grass and there's concrete if you look at the railing.
Okay. And which did you fall on?
I fell over here.
On the grass?
No. I went over here, fell right over.
So you're saying you fell down the steps?
Mr. Miller, the witness has communicated with you, testified that she's holding what has been marked as a defense exhibit C, and she's saying over here. The record has no idea.
Okay.
So you can describe
All right.
exactly what she has pointed out to you, so we and the record will understand what over here means.
Okay. There is a railing, correct? In the photo.
Yes.
And there are steps coming down from that porch.
Mm-hmm.
And there's a railing.
Yes.
Yes.
And you're saying that you fell down the steps onto the concrete, right?
Yes.
Okay?
Onto that flat part there.
Okay. All
The
right.
walkway.
Okay. All right. And those are the steps that lead into and out of the side door, right?
Yes.
And that's where he pushed you out, right?
Yes.
Okay. Now, once you got outside, you were upset, weren't you?
Yes.
And I'm going to ask you again, at that time, did you yell out, I'm going to kill that bitch?
No.
At that time, did you yell out that I'm going to fuck her up?
No.
Now, but at that time, you went to the front porch and picked up a chair, did you not?
Yes.
And that was a wicker chair, right?
Yes.
and you were going to use that wicker chair against Mr. Smith.
Counsel, are you saying that a wicker chair is a dangerous weapon?
Yeah, it can be.
It can?
Well, let me show her the picture.
Against a person who's in a home?
Judge, I haven't finished yet.
Yeah, but I want to focus this in because counsel, just in the allegation, you're asking her if she's going to use a wicker chair as a dangerous weapon.
Yeah.
Certainly, to a testimony I heard when Mr. Smith is in the house because you went into the questions how he has removed her from the house.
Correct.
And she picks up a chair. So how does a wicker chair become a dangerous weapon?
All right. Now, you go outside. You pick up the wicker chair, correct?
Yes, from the front porch.
And Mr. Smith is standing on the front, on that side porch, is he not?
He's inside.
Okay, he then comes out.
Yes.
And he's standing on that porch adjacent to his house. It's set forth in exhibit.
He's standing on the side porch.
At what point, counsel? At what point? I have no idea. Was he out before she picks up the chair, after she picks up the chair, after she throws the chair, or when? The questions are just not being specific enough for me to understand what is going on. At what point was he on the porch? Because you said at some point he comes out. When?
Right.
I don't know.
He comes out after
No, you have to ask the question, counsel.
that's what I'm asking her. He comes out after you're outside and after you pick up the chair.
He comes out after I throw the chair
Okay. And you threw the chair where?
up in the air.
Oh, you just threw the chair straight up in the air.
And it hit the porch, yes.
The porch that he.
That it was on, the front porch.
Okay, so now you're saying that the chair.
Counsel, when you say now, you're saying I haven't heard anything
Okay.
that indicates this is a change.
Correct.
Now, in your statement, however, you did not say that you, page 3 of your statement at the top of the page. Do you recall saying in your statement, he opened the door and pushed me outside? Then he pushed me over the railing onto the concrete.
Yes.
There's no railing at the steps.
There is a railing on this picture here. This is the railing.
Okay.
This is where
I thought you said that you fell down the steps onto the concrete.
I said that I was pushed out, hit the railing, fell onto the steps,
Okay.
onto the concrete.
Okay, so you hit the railing, fell down the steps onto the concrete.
Yes, this part of the railing is where I had the impact and fell over.
But in your statement, you said he pushed me over the railing,
My statement,
right?
right.
Okay. Now, and in your statement, you said that I walked to the front porch and threw a wicker chair.
Objection, where's the impeachment? There's
Well-
no impeachment.
Counsel, the prior statement of the witness can only be used for a limited purpose. That would be to rebut claims of recent fabrication, to impeach or refresh. I haven't heard anything that would come into either of those categories.
Okay.
Thank you.
Did you not testify that you went to the front door, went to the front of the house,
Yes,
picked up a chair, right?
yes, I did pick up the chair.
And threw it up in the air.
I object, Your Honor. She indicates she threw it on the
Threw it
front
up
porch.
and she said it landed on the front porch.
Your
She
Honor.
said that, counsel.
Okay, on the front porch.
Yes, sir.
Now, in your statement, however, you said, I walked to the front porch and threw a wicker chair.
Objection, Your Honor.
saying because there is something that, where is there something that is different in that statement? Because she doesn't say the porch, it landed on the porch. So a person's statement has to be consistent if they use exact words. That's not impeachment, counsel.
Judge, you can give what weight you want to what I'm attempting to.
I'm saying it doesn't come in. You cannot use a person's statement. You cannot use it for anything but the three limited things I've explained: to rebut claims of fabrication, to refresh, or to impeach. And that is not impeachment.
Well, throwing a wicker chair, using the word "I threw a wicker chair" is different than saying I threw a wicker chair up in the air.
That's not different, counsel. That's not different.
Okay.
It might be different if she said I threw a steel chair. That might be different. She said I threw it because in one statement she says where it landed doesn't make it a different or something that can be used for impeachment.
I leave it the judge to make. All right, I leave you to your. Okay. All right. All right. Now you go back to the side of the house, correct?
No.
You never go.
I go to the edge of the grass where the front of the house is, which is the corner.
Okay. And you see him on the porch.
On the side porch.
On the side porch that's in Exhibit C.
Yes.
At the door of the side door.
He was on the porch, yes.
And you see him with the gun.
Yes.
Okay. And you say he shoots the gun up in the air.
Yes.
And then you say he pointed the gun at you.
And start shooting, yes.
Okay. Now, so you're saying now when he shot the gun up in the air, you didn't start running?
No.
Oh. You stood there.
I didn't think he would shoot at me.
Okay. Now, how many feet was he from you?
Judging, maybe, I'm not really good with judging feet, but maybe 12 feet.
Could you point to something, if you're looking straight from where you are, point to something in this courtroom along this axis that would approximate the distance?
It would be from here to approximately close to where that back wall is, here,
All right.
to where I was standing.
Deputy, the distance to where you're standing is what?
And it's further back
Hold
to
on,
the
we're gonna take care of that.
16 feet.
Okay, 16 feet to where the deputy is. So if we add another 6 feet, would you agree with that, Mr. Gill?
Yeah, I stipulate, counsel.
Judge,
It's a known distance to where the deputy is standing.
Okay, fine, yeah, I do.
And say, I would say it's another additional 6 feet or so to the rear wall.
Okay.
Maybe a little bit more.
Okay.
Okay, so we're stipulating to, what did I say, 6?
22.
22.
I'd like for you to take a quick look at that picture. And does that picture refresh your recollection as to the side of the house and its relationship to the front of the house?
Yes, and so,
Just a minute. And does that assist you in pointing where you are standing?
yes, it does.
Okay. I like to have that marked as Exhibit D. Any objection?
No objection.
May I publish it?
Yes.
This one has C. That one should have D.
This is G, the photograph is
looking at that photograph, were you standing near that
That's not
railing?
counsel, because you have now, you know what the photograph is, the witness knows what the photograph is, you published it to the court, I have no idea what it is, so you have to lay a foundation, ask some questions to the witness, is it fair and accurate representation of something, and what is it?
Okay. Is that the side of the house of Mr. Smith?
I
Exhibit
don't
D.
see, I don't see a house there at
Well-
all. I see a house in the distance. So are we
There-
saying that this is the walkway that would be to the side of Mr. Smith's house?
Yes.
Okay, because I don't see a house in the picture, so.
Well, it's right to the left, Your Honor, it's right to the left with the window, the house.
I don't see a window, on the photograph that you just showed me, I see a partial railing, and that is it, and I see some hedges, and some grass. And I see a van
All right,
and
fine.
a portion of a car.
Okay.
But I don't see a house.
All right. Now, are you standing in front of the railing?
No.
On this picture, where are you standing next to the shrubs?
No.
Are you standing close to the railing?
Objection, asked and answered. She already said she wasn't standing close to the railing.
Counsel, might you just have her take a pen or something and mark on the photograph where she was standing?
No,
As opposed to
well,
asking
well,
a bunch of questions that she'll just keep saying no to?
well, Judge,
Tell me exactly where she was.
well, I'll let her mark on my copy. I don't want her to mark on the picture. Would you mark on that picture where you were standing?
It's actually an exhibit, sir, so you should be marking the exhibit. If you're gonna at some point introduce these photographs, should he go to trial and say at the examination, she testified to an exhibit, and it would have to have her markings on the exhibit.
Mark it on there. Now, at this time, Mr. Smith is still on the porch, right?
Yes, you have to say for the record where she marked it.
For the record, I asked, you marked it near the railing, right? In the front of the house,
I marked it near the short fence there.
the short railing fence, whatever you want to call it.
Whatever you want to call it.
Yeah, it's a metal fence of some type.
Well, I see a railing which would go to stairs, and I see what looks like a short fence that goes around the house. So,
And it's the short
and
fence.
that's why I need to see what it is that we're talking about, because, we're mixing railings and fences, and
I was standing by the short
fine,
fence.
I see it.
Yes.
You're standing by the short fence.
Yes.
Mr. Smith is on the porch.
Yes.
Mr. Smith has a gun.
Counsel, so we're clear, Mr. Smith is on which porch?
The side porch.
And the fence that we're looking at is at the front of the house, is that correct?
It's at the corner of the front and the side of the house. It abuts the front of the house as well as the side of the house. If the court looks closely. It's
No, it's a railing that goes along the front of the house, that's what I see.
and also, if you look closely, it comes up the sidewalk a
Yeah,
little.
okay, but she's indicated that she was at the front of the house, she's indicated that.
Okay. Mr. Smith is on the porch as set forth in Exhibit C, right?
Yes.
On the side of the house as set forth in Exhibit C.
He is on that porch. Yes.
Okay. With the gun.
Yes.
And he shoots the gun from that porch.
Yes.
You were not hit, correct?
Yes, that is correct.
Did Mr. Smith has his clothes on?
Yes, it is.
Now, when you went, let's go to the subsequent events. When you went to Carlos Cade's house, you did not know your car had been shot at, correct? Now, did you not only see flashes of the gun firing?
When you say, did I not see?
Did you see flashing of the gun firing?
Yes.
Did you feel any bullet come past you
Yes. Behind me.
as you were running?
When I was going forward, I was facing north. I was dodging. Then I saw muzzle flash,
Muzzle flash?
and I started running.
Okay.
I was dodging whatever was coming at me.
Okay. Soon as you saw muzzle flashes, you ran.
Yes.
Okay. Now, has your father ever threatened Mr. Smith in the past?
Your Honor, I'm going to object.
Okay. I will tie it up later, Judge.
No, you're not going to tie it up because unless you can show how somehow that has any relevance at all. Because I haven't heard any testimony that her father was there on that evening or anybody
All right.
else.
Are you aware that your father?
Can we
I withdraw that.
Can we approach him and find out so he doesn't put all kinds of inflammatory stuff on the record that's not admissible? That is not proper.
We did have a sidebar where we did discuss, or back on the record, I should say, back on the record on 1557895, the attorneys and court had sidebar discussing the last question by Mr. Dillard. Something that I do not find to be something that would be relevant, admissible, and quite frankly, I don't even know how relevant. You know, normally we strike the answer, but I'm going to strike the question as well.
Thank
I haven't
you.
found it to be relevant at all.
Okay. Now, you did a Facebook posting regarding this event, did you not?
No.
I think I told you.
Now, I didn't hear your answer.
Your Honor, at this juncture, I'm going to object by way of authentication. It has to be authenticated before he can use anything. He has to show that it is in fact, it came from her, that it's not a page made up by somebody else with images, using her images and things like that. Not authenticated, objection.
Fair enough. Can I present it to the witness to see if whether or not she can
You can ask
identify?
her if she-
That's what I intend to do.
Is this your face? Take a look at that, please. posted that?
I did post that, yes.
Objection to relevance is something that was posted after the fact. How is that relevant?
Well, I don't know what it is, counsel, if it's some type of statement indicating
Can
that
we
the
approach
witness
and
has
show
done
the-
something like, you know.
Approach and show the court.
Court has had an opportunity to review a posting made by the witness who indicated it was her posting. I don't find it to be relevant to the evidence or to what has occurred, so it would not be admitted. We'll make a complete record of it.
I have nothing further, Your Honor.
Nothing further this witness, Your Honor.
May this witness be excused.
Yes.
Thank you,
Ma'am,
ma'am.
you can step down, you're excused.
Before we, can I have a few minutes just to reorganize these photos? Just a second before we.
Oh,
call
I
you
do
in.
have one additional question. Can I see your photograph, the
Which
one
one?
you had the
The seat,
railing?
the
No,
seat.
the
She might have it over there.
Which photo?
the photograph that showed the railing in the front. She
Yeah,
made
she has that.
Okay. I do have an additional question. In terms of where your car, your Mercedes-Benz was parked at the front of the house or the side of the house?
On the side of the house.
Okay. I'm using the defense exhibit D. There are two vehicles in that photograph. Could you approximate where your car was parked?
It was further back beyond that because it was closer to the bedroom.
Okay, so it's further back. So where your car was parked on the side would not even be shown on this photo.
Correct.
It would be, ma'am, would it be behind the, there is a black vehicle showing in the photograph. It looks like it might be a older Mercedes or something, I'm not sure. But it's a black vehicle. Would it be behind
I
that
have a
car?
better photo of that.
Yes, it would be behind where that car was parked.
That clears the record up as to where the car was.
Nothing further.
Ma'am, you may step down.
I have one additional witness.
Just let me just follow up that, Judge. I want to make sure.
You can't clear it down yet.
With the location of the car. I'd like to show you this photo. Does that, looking at that photo, does any car in that photo more accurately reflect where you're?
Mr. Mills, again, we're gonna have to mark the photograph so we can, so the record can reflect, and if anybody look at this transcript later, they'll know what we were looking at. Because right now, you say, I'm showing you a photograph, later on at some other hearing or review or trial or anything, I don't know what may come, but certainly no one will know what we're talking about. So we have to have the photograph marked as an exhibit, have the witness give some explanation as to what is in the photograph, and then you can go from there.
Judge, normally what I would attempt to do is first identify the photograph and then I would move.
Yeah, but you gotta be talking about something, sir, so it's gotta be marked. So you can say, I'm showing you exhibit whatever. If you tell us what's in the photograph, is that a clear and accurate reflection of what it purports to depict, and then whatever questions you need to go into.
Whatever I like to look at what has been marked as exhibit number.
All right, now,
Looking at that photo.
okay, you have to speak up, Council.
Looking at that photo. photo reflect more accurately the location of your car on that evening?
I would have to mark it as to where my car was parked.
Well, does it reflect it or does it not? You said, I think previously, that your car was closer to the bedroom.
It was.
Does that photo
Does
reflect
the
where your
photograph
car?
show the bedroom, or does it just show?
Yes, it does.
Shows it?
Yes, it does show the bedroom.
And it shows the car in front of the bedroom window, right?
Yes, it shows a
And-
car.
Yeah, and is that car reasonably located where your car was located?
My car wasn't further a little more behind that. So it wasn't exactly where this car is parked. Because Virgil's car was much closer to where this porch is.
Okay.
So I was behind that.
Okay. So in other words, that picture does not reflect the location of your car or Mr. Smith's car on the evening in question, right?
Council, that's, she's not saying, her car's not in that photograph, right, correct?
Correct.
So she's showing, she said, I can mark the photograph to show you where my car was located, to say, because does it show the area that your car was parked?
No, this is inaccurate. If he's saying it's in place of where this
No,
car is.
no. I'm not asking you about the cars that are now depicted in the photograph. Does that photograph show the general area that your car was been parked?
Yes, it does.
That's what she's saying, Council. You're asking about the photograph, the cars that's in the photo. She said it's not where these cars were, it was behind it. And she indicated, I can mark the photograph to show you where my car was located. So her car.
Mark where your car is.
Thank you.
May I approach
Are
the
we
photo?
asking to admit the photograph? Is there any
Yes,
objection
sir.
from the people?
No objection, Your Honor.
So admitted. In fact, all of the photographs and the evidence that has been marked by the defense is admitted.
Do you have all four pictures up here?
I have 3 pictures up there along with it. I have no originals, but that's fine. I got those. All right.
Okay, here's the
No, that's fine. That's fine. That's fine. I don't need scrapbook. I mean, I got it. You can have it.
Okay, I have nothing further with this.
Nothing further, Your Honor.
Third time's the charm. Jimmy, step down there.
Thank you, Your Honor.
And again, you're excused. You can leave if you choose to. You can take care of another witness.
Yes. One last witness, yes.
You don't have to come. Just raise your right hand. State your full name.
Tatiana Grant.
You swear or affirm to tell the truth, the whole truth, nothing but the truth. Please have a seat in the witness chair. Swing that microphone directly in front of you. Just keep your voice strong so we can hear you.
Okay.
Your witness.
Good morning, Ms. Grant.
Good morning.
I'm going to direct your attention back to the early morning hours of May 10th, year 2015, at approximately 1 in the a.m. hours. Were you on Wexford Street?
Yes.
And were you with someone in this courtroom?
Yes.
Hold on, witness. Ma'am, you can't stand neither of you can stand in the courtroom. You're in the back trying to stand up, so you can't do that. Keep your seats.
Were you with someone who's in this courtroom?
Yes.
And would that be Mr. Virgil Smith Jr.?
Yes.
Do you see him seated anywhere?
Yes.
Could you point him out and tell me what he's wearing?
Right there, and he has on, it looks like a robe brown suit with the blue button-up.
Indicating for the record, the witnesses identified the person of the defendant, Mr. Virgil Smith Jr. Now, ma'am, could you tell me about something occurring in the 1 a.m. morning, around 1 a.m.? Do you recall what happens?
Yes.
Okay. You were asleep?
I was asleep.
Okay. And are you awakened?
I was, yes.
Okay. And were you awakened by something?
Yes.
And what were you awakened by?
I was awakened by hearing Virgil speaking to someone through the window.
Okay. So you were awakened by Mr. Smith's voice, is that correct?
Yes, that's correct.
Okay. And could you hear the person outside?
No, not initially.
Okay. So you first hear Mr. Virgil Smith's voice speaking to someone outside, correct?
Correct.
And you did not hear, or you could not hear what was being said by the person outside, is that correct?
Yes, that's correct.
Okay. What do you see Mr. Smith do next?
After I heard him wake up, or after I woke up and heard him speaking, I kind of like looked over and saw him closing the window and going over to put on some pants.
Okay.
After I saw him...
Now, let me stop.
Oh, okay.
Stop you right there. Did you have a cell phone that was working at that point in time?
Yes.
Okay. And it's for best you know that Mr. Virgil Smith had a cell phone that was working at that time?
Yes.
Okay. Mr. Smith, did he ask you to call the police?
No.
Did Mr. Smith himself call the police?
Not to my knowledge.
Okay. So you see him putting on his clothing, is that correct?
Yes.
And what happens next?
As I see him bending over, putting on his pants, the window opened up from the outside and caused me to kind of jump up, startled, because I'm looking at him, and the window opens.
Okay. And do you hear something?
Yes, I hear a woman's voice.
Okay. When you hear the woman's voice, could you make out what was being said?
I feel like she said something like, "Come on, Kai."
Come on, Kai.
Something like that.
Okay. And at that point in time, do you pick up your cell phone to call the police?
No.
Does Mr. Smith pick up his cell phone to call the police?
No.
Okay.
He went back to the window.
He went back to the window, and do you hear more conversation?
No.
Okay. So what happens next?
He closed the window and then went to the bedroom door and said, "Tati, don't come out this room," and closed the bedroom door.
He said, "Tati, don't come out this room."
And
Correct?
closed the door and exited.
Okay. Up until this time, the person on the outside had never addressed you, is that correct?
That is correct.
You hadn't heard any threats towards you from the outside?
Correct.
Prior to you being woken up by Mr. Smith's voice, did you hear any loud banging or any screaming, any cursing?
I did not.
Okay. So the thing that woke you up is Mr. Smith's voice?
Yes.
Okay. Now, he tells you to stay in the bedroom, is that correct?
Mm-hmm.
What happens next?
You have to say yes or no.
Yes.
Okay, because the court reporter can't take down, okay?
Gotcha, yes.
Okay. So what do you hear happening next?
After that, I heard the door to the house close, and I just heard running.
Okay.
Running through the hallway.
Okay, then what happens next?
Then the bedroom door burst open,
Okay.
and Anicia came in and jumped at the bed. At this point, I'm still sitting up from when the window opened. I'm still sitting up like this with my feet straight up in the bed.
Yes.
And the bedroom door burst open, and she jumped out the bed to where my feet were.
Okay.
But instead of grabbing me, she grabbed the sheets.
She grabbed the sheets.
Yes.
And what did she do with the sheets?
She's holding them, and Virgil's behind her, kind of like pulling her back. I don't know if it was her arms or her waist.
Okay.
But she's also, as she's grabbing the sheets at me, she's also yelling at me.
Okay. Does she pull the sheets off you?
No, at this point.
Okay. At this point in time, does Virgil tell you to call the police?
No.
Okay. And at this point in time, do you make any attempt to call the police?
No.
Okay. Now, I'm going to back up a little bit. Were you aware of some type of firearm that Mr. Smith had?
Yes.
Tell me about that.
About a year ago, Virgil...
Objection. What's the relevancy of a gun of a year ago to this case?
I don't know if she's talking about when the weapon was purchased. Certainly, if she can talk about if she's had a gun and it's something consistent with the charges today, that would be relevant that he possesses that type of gun.
Thank you. What type of gun did he show you?
Honestly, I didn't see it because when he pulled it out to show me, I told him I didn't want to see it and didn't want to be around it.
Okay, well, Was it a short gun or a long
It
gun?
was a long gun.
Okay. And did he tell you where he kept that long gun?
No, but I saw where he got it from.
And where did he get it from?
From under his bed.
Okay. Now, so eventually she yanks the sheet off?
He pulled, in the attempt of him pulling her away from me, the two of them fell back, and she was still grabbing the sheets. She in the sheets, and him fell back.
Okay. And then do you see some tussling going on between them?
I don't see a ton of tussling. I can hear it.
Uh-huh.
And then I heard crashing of the television, which is the complete furthest corner of the bedroom.
The complete furthest corner of the bedroom. At this point in time, did Kai yell out to you, call 911, call for the police?
No.
Okay. Did you, based on what was going on, reach for your cell phone and call the police?
You know,
No.
relevancy. What's the relevancy of calling 911?
The relevancy is there's some allegations that somebody was so threatened or so afraid, then the natural inclination you might think would be to call the police.
Correct.
But that's pure speculation.
No.
She can ask, did they call? You can ask. You ask about my phone calls, counsel.
Okay.
Because
So-
you know your person's state of mind, so you can do that.
Now, at this point in time, can you hear anything being said?
Excuse me. Yes. She was yelling things like, he doesn't care about you, he doesn't love you. And I remember in my brain as I was processing it, that she was yelling and he was kind of calmly saying, I did not say that. I did not say that,
Okay.
in response to what she was yelling out.
So when she was yelling, he doesn't care about you, he doesn't love you, that didn't cause you to pick up the phone and call the police, correct?
Correct.
And at that point in time when she was yelling out, he doesn't love you, he doesn't care for you, he did not say, call 911.
Correct. And I was honestly kind of in shock.
Okay.
It didn't even dawn on me to call anybody.
Okay. Now, does he eventually get her out of the bedroom?
Yes.
Okay. And after he gets her out of the bedroom, do you see him, so he leaves the bedroom, is that correct?
Both of them, he kind of grabbed her up and took her out.
At some point in time, does he come back in the bedroom?
Yes.
Do you see him do something?
When he came back into the bedroom, he didn't do anything at first. I started yelling at him, where are my contacts? I can't see.
Okay, where are your contacts? You can't see. And at that time when he came in the bedroom, do you know whether or not he attempted to call 911?
Not to my knowledge. As soon as he gave me the contacts, I put them in my eyes.
Okay, you put your contacts in. Do you see him do something?
Shortly after that, I didn't see him. I heard.
Okay, what did you hear?
I heard the gun hitting the bed frame.
You heard the gun hitting the bed frame. Where was Mr. Smith when you heard the gun hitting the bed frame?
Next to the bed.
Okay. Based on what you heard in his position, did you believe he was getting the gun out from up under the bed?
Yes.
Okay. At that point in time, based on what you know, did Mr. Smith have a working cell phone?
Yes.
Before he went and got the gun, did he pick up that working cell phone and call 911?
No, I did not see that.
When you saw him getting the gun, did you pick up a working cell phone and call 911?
No.
Did you say anything to him when you saw him do this?
No.
What's the next thing you see or hear?
After that, all I cared about was getting myself out of there.
Okay.
So as I heard that, I heard it, but that wasn't my focus. My focus was to get all of my stuff and to leave. So I heard it and started grabbing my things so that I could leave.
In terms of after that, when you were making an effort to leave, is after he got the gun, is that correct?
They were simultaneous.
Okay. Simultaneously with him getting the gun, you were like, I gotta get out of here.
Yes.
Okay. At the point in time when he is getting the gun, did you see Anistia?
No.
Could you even hear Anistia when he was getting the gun?
No.
Do you hear or do you hear shots or see muzzle flashes?
Yes.
Tell me about that.
So I heard the bedroom door close. Not the bedroom door, the house door close.
Mm-hmm.
And at this point, I am in the process of gathering my things. And I hear 4 gunshots. And as I was hearing them, I kind of looked toward the window, and I could see, like, lightning
And based on what you heard and what you saw, did you believe that to be muzzle flashing?
I didn't know what it was at the time, but yeah.
Okay. At the point in time when right before you saw the muzzle lightning and you heard the gunshots, did you hear anesthesia or did you see anesthesia?
No.
What happens next?
So after that, it was oddly quiet to me. I didn't hear glass breaking, I didn't hear yelling, I didn't hear police cars, I didn't hear anything. So I knew not to go over to the window where I just saw that happening.
Okay, so based on everything you told me here, you did not see or hear anesthesia?
Yes, that's correct.
Okay, go on.
So then I knew not to go over to the window where I just saw the flickering through the window. So I looked out the back window to see if I could see something, see or hear something.
Okay.
And I didn't. I don't see the dog. All I see is the backyard and the garage. And then it clicked in my head, my car is in the garage. Now that you have your stuff, how are you getting out of here?
Okay. What happens next?
Then
Now at this point in time, you still have your cell phone.
This entire time my phone was plugged in at like next to and underneath the bed, all under the bed.
Okay. Now where is Virgil at this? The defendant at this point in time? Do you know?
I have no idea. He wasn't in. At least he wasn't in the bedroom with me.
Okay. Now how long were you in the bedroom by yourself before Mr. Smith, the defendant, reappears?
Reappeared when he gave my contacts, or after that?
After the shooting.
Okay. After that, it was at least 3 to 5 minutes. It was a little while.
It was a little while.
Mm-hmm.
And when he comes back, does he come back with the gun?
No.
When he comes back without the gun?
Yes.
Did he say anything about where the gun was?
No.
Did he come back by himself?
No.
Who did he come back with?
Carlos.
He came back with Carlos.
Yes.
And what happens at this point in time?
The two of them come in. I can't remember which one of them it was.
Okay, don't tell me what they said, but did you leave the house at that point in time?
Yes.
Okay, and you got into your car and left?
Yes.
During any of this time, did the defendant, Mr. Smith, call 911?
Not to my knowledge.
Did he ask you to call 911?
No.
Did he complain of any injuries?
No.
And you left, is that correct?
Yes.
Did you have contact with him later on that day?
Yes.
He called you?
He called me.
Okay. Did he ask you not to tell anybody about what happened?
No.
Did he tell you where the gun was?
No.
Did you see Anistia's car when you left?
Yes.
Okay. Could you tell whether or not there was any damage to it?
I didn't see any damage.
Okay. Were you looking?
No.
Okay. Nothing further this way.
Good morning, Ms. Grant.
Good morning.
Okay. Now let me ask you, you had been with Mr. Smith that evening, had you not?
Yes.
Was Mr. Smith drunk at all that evening?
Not to my knowledge.
Now, when you awoke that evening, did you see Mr. Smith open the window?
I did not see him open the window, no. I heard him talking through it.
But subsequently to that, he closed the window, did he not?
Yes.
And the window after that opened up again.
Correct.
Was that window opened up again by Mr. Smith?
No.
Was it opened up by somebody outside?
Yes.
Did that cause you fear?
It caused me to be startled because I'm looking at him putting on his pants in some kind of a way. The window opened up on the outside.
While he's putting on his pants?
Yes.
Now, at that time, he did not have a gun, did he?
No.
Now, he then leaves the room, correct?
Yes.
And the next thing that you notice is you hear running.
Yes.
Did you hear any noise relative to the side door of the house?
Closing?
Or opening?
The door kind of slams when it closes. So I heard that, and then I heard
okay. You heard that side door of his house slam.
Mm-hmm.
You then hear running.
Yes.
Now, when Mr. Smith left the bedroom prior to this incident, he closed the door
Yes,
and told you not to leave the room.
that's correct.
And then the bedroom door burst open.
Yes,
And is it Mr. Smith you first see, or is it Miss Grant that you first see?
it's Miss Thomas.
Excuse me, Miss Thomas. Excuse me, Miss Grant. Apologize. Miss Thomas that you first see.
Yes,
And she's running towards you, isn't she?
yes.
Were you concerned about her running towards you?
I don't know if it was concern or more so like what is going on.
Okay. What is going on? Now, was Mr. Smith behind her?
Yes.
Was he chasing after her?
He wasn't chasing her. He was trying to restrain her and keep her from me.
Okay. So from behind her, he's attempting to restrain her by pulling her back from going in your direction.
Correct.
But he wasn't successful.
Not at first.
Not at first. Because she actually attempted to grab your legs, didn't she?
Yes.
But instead she grabbed
The bed sheet.
the bed sheets. And she tried to pull you from the bed?
I don't know what she was trying to do.
Now, you said, I believe on testimony, that you saw Mr. Smith put his hands around her from the rear and crossing his arms across her chest or stomach area?
It was either her arms or her waist, but whatever it was, I could tell he was trying to pull her back and she was trying to get to me.
Okay.
And the two of them fell.
Okay. So in the process of pulling back, they then fall over the TV?
No.
No.
This was before they got to the TV.
Okay. So they fall back.
And the sheets still holding on to the sheets, and the sheets go flying back with them.
Now, did you see Mr. Smith punch Miss Thomas in the face?
No.
Did you see Mr. Smith slam Miss Thomas's face into the floor?
No.
Did you see Mr. Smith assault her in any manner whatsoever?
No.
What you saw was simply him restraining her.
Pulling her back and then carrying her like this from the back out of the room.
All right. And, okay, did they fall to the ground before the TV incident?
Yes. That was with the bed sheet.
That was with the bed sheet. Did they roll over?
I still don't know how they got over to where the TV was, but I feel like I could hear them kind of struggling, and then I just heard like a crash.
Okay. And then you saw them fall over the TV?
It was so dark, I honestly didn't see it.
Okay. But you heard it?
I heard it
All right.
and knew what it was.
All right. There came a time later in the evening, that you did actually see the TV knocked over, though, right?
Yes.
Okay. All right. So after the TV encounter, is Mr. Smith still pulling her out from the bedroom?
Yes. And
as he's pulling her out, is he punching her in the face?
no.
Is he slamming her head into the wall?
No.
Does he back her out of the room?
He didn't back her out. The two of them wound up kind of by where the bedroom door is, where the blue chair is. And the two of them were over there, and I just recall seeing him kind of like get her from the back and then taking her out of the door.
So you saw him lift her up.
Because both of them were on the ground.
Okay. And so he stands up
Yeah.
and lifts her up.
I don't remember if he lifted her up or some kind of way they both got up, but I just remember seeing his back to me, and it was kind of like,
Yeah.
like seeing somebody getting somebody up.
Holding. Okay. And he carries her out of the bedroom?
Yes. And he also told me, don't come out the room.
Don't come out the room. Did you feel that did you draw into conclusion as whether or not Did you know where Mr. Smith took Miss Thomas?
No.
Do you know if he was removing her from the house?
I assume so because I heard the door close.
Okay, you heard the door close again.
Yes.
Now, Mr. Smith was fully dressed at this time, was he not, when he's taking her out? You have to say yes or no. Okay. Now, you didn't see Mr. Smith shoot at the car, did you?
No.
You didn't see Mr. Smith shoot at Miss Thomas?
No.
Now, after the muzzle flashes that you see out the window, was there a car nearby those muzzle flashes, if you recall?
All I could see is through the window blinds, like lightning. So I don't know where the car was in proximity to anything because the blinds were closed.
Did you ever see Miss Thomas's car?
When I was leaving.
Okay, when you was leaving. Now, there came a time that Mr. Cade, Carlos Cade, came encounter with you?
Yes.
And what did he do?
He and Virgil escorted me to my car.
When you say they escorted you to the car, why was it necessary for them to escort you to the car?
Objection, Your Honor. She would be speculating as to what was in their minds.
I don't think that calls for speculation as to their mind. She's simply saying what occurred.
She can say they escorted her to the car. Now, what's in their mind, why they say it's important to do so, she can't speculate to that. She can testify that they escorted her to her car, and she did so. She can't say what's in their mind.
Did you think it was necessary for you to be escorted to the car? Did you think?
Yes.
Why?
Just based on everything that happened, I wasn't walking in my car by myself.
And why not? Were you afraid of Miss Thomas?
There was fear, yes.
She had attacked you, had she not?
She attempted to.
And the only reason she wasn't successful was through the efforts of Mr. Smith.
Correct.
But for Mr. Smith, what do you think would have happened?
I have no doubt in my mind she would have tried to fight me.
Now, when you were escorted to the car, did you notice Miss Thomas outside at all?
No.
Did you see Mr. Smith with a gun at all?
No.
I have nothing further, Your Honor.
The level of fear that you had was not such to the extent that you called the police. Is that correct? That is correct. Truly, if you believed that you were in fear of death or great bodily harm, you certainly would have picked up the phone and called the police, correct? I would think so, but the police never crossed my mind. Okay. But you're an intelligent woman, correct? Yes, correct. I'm sure you have some advanced degrees. Yes. Okay.
Objection. That's speculation, Your Honor. That's speculating.
She's speculating about her own degree?
No, the speculation is about whether or not she would call the police. She's previously testified that her...
You can testify what you would do, counsel.
She didn't testify to that, Judge.
No, she can ask her.
And at no point in time did you pick up your cell phone that was right next to you to make a call, correct?
Objection. The telephone was not right next to her. It was plugged into the wall she testified to. That's not an accurate statement of what she said.
Well, certainly, counsel, all of these things have a point in time. There's testimony that she grabbed her stuff and she left. So Ms. Lindsay, you have to clear up
Okay.
at what point in time.
At any point in time, was your cell phone within reaching distance?
Yes.
And at no point in time, when your cell phone was in reaching distance, when any of this was going on, did you pick up the phone to call for the safety of anybody?
Correct.
Now, in terms of what you said,
And
you
that was a question that,
Okay.
did you at any
Okay.
time, and you said correct.
okay,
So
Did-
that's
okay.
a responsive answer.
okay. Did you at any point in time, when the cell phone was within your reach, call the police over concerns for safety of anybody in that house?
No.
Now, defense counsel asked you several questions about what you saw or what you didn't see during the assault, correct?
Yes.
Now, you indicated that you had your contacts out, correct?
Yes.
And when you gave your statement to the police, didn't you indicate that you could only see figures because you couldn't see?
I saw shadows and shapes.
You
Yes.
saw shadows and shapes.
Yes.
So in terms of him asking you, did you see specifically this or that? The room was dark, correct?
Yes.
Your contacts were out, correct?
Yes.
And you saw shadows and shapes.
Yes.
So in all accuracy, you cannot say what hands were doing at any given time. Is that correct?
Correct.
Nothing further?
But you have no doubt that Miss Thomas was attacking you.
No doubt.
You have no doubt that Mr. Smith was trying to restrain her.
Correct.
You have no doubt that Mr. Smith was removing her from the bedroom to prevent a further attack from you.
Yes.
You have no doubt that you heard running into the bedroom.
No doubt.
You have no doubt that when the
This
door
judge,
burst.
This exceeds the scope of my redirect. I was willing to let a few things go, but he's going all the way back into things that I did not ask. So exceeds the scope of my redirect.
Counsel, I always let people go beyond the scope, but at some point, you're asking about what her doubts were without any type of anything that suggests that her doubts might not be fanciful. She's already indicated what she could not see. So her doubts and all of those things are based on a belief that's not been substantiated by what she could see.
Okay.
So
Let me. Did you or did you not see Miss Thomas run into the bedroom?
Yes, I saw that.
Did you or did you not see Mr. Smith attempt to restrain her?
Yes.
Objection at this point of time, under Michigan rules of evidence, this is all cumulative. All he's doing is having
No.
to repeat over and over what's already been
No,
testified
no.
to.
it is all testimony that is on the record. There's nothing new that has been said or asked.
Well, Judge, I certainly, if Madam Prosecutor is suggesting that because she does not have her contacts on,
No,
that
she said
somehow.
that. I wrote it down.
I understand that.
Hold on. She said, I wrote it down because I thought it was important. She said, I did not have my contacts on. I couldn't see anything.
Yeah,
She
and so
said that.
and so therefore I am now coming back
You
to
did it
ask
already,
her.
though. You did it already. I
I'm
heard
do-
the answer the first time. It's not different now. She said it. You asked, did she see Mr. Smith restrain Miss Miss Thomas? She said it. So you're asking again.
No.
She said she saw it.
No.
Because I expressed that she had said something at one point that said she could not see anything, but she did say it, and you're asking again. It doesn't change it. I heard it the first time. I heard it. I heard her say she saw Mr. Smith restrain Miss Thomas. I heard her when she said he wrapped his arms around her and was pulling her away. I heard her when she said she saw them fall to the floor. I heard her when she said they were on the floor and he put his arms around her and he got her up. I heard it. Having her say it again doesn't make it any, if I hear it 3 times, doesn't make it 3 times as strong. I heard it. I heard it.
Nothing further, Your Honor.
Nothing further, Your Honor.
Now, you may step down. Can this witness be excused?
Yes.
You're excused, ma'am.
People move to bind over his charge in the complaint warrant as
Ma'am, you're a little premature.
okay.
Do the defense have any witnesses?
Yes, we do.
Okay.
Yes, we do. Can we take a little break to go out there?
Before we do this, we got to get some. The witnesses that you are calling, are these just eyewitnesses?
Yes.
The people got revealed.
Yes.
Okay, well, can we have an offer of proof? Because if all he wants, well, no, let him do it. I don't care.
Yes.
We'll take 10 minutes.
Thank you.
Do we have anything that we can do quickly?
Is the night holding? No. Waiting.
You want to take lunch and then if you can help with my Friday night. And Larry Williams.
I'm gonna go get lunch then.
Okay. Can we see for, sir? Can we see if we're gonna be able to do your case today?
Right now?
No, if we're gonna be able to get to it today at all.
Yeah, Brian.
Yeah, can you bring them all in?
Well, you get some overtime money.
What's going on, Mr. Edison?
What's up, girl?
How are you?
Good. You part of this,
No, I'm just trying to
get in and out?
get in and out.
You too, girl. I ain't even supposed to be here.
Why? So why you here? How you looking?
Case got up here and Gary Jones is on it. He's not here. And just trying to get put to another day so you can come on in.
It's not really. Let's go. Let's go. Where we go? Yeah, that's true. I mean, I wouldn't blame them. I'm gonna stay around here.
Right. Who are you calling? Miss the girlfriend?
Okay.
The girlfriend?
No, I'm gonna call her. I gotta call the other two women across the street. They live across the street on Wexford. From
Do I have witness statements from them?
I didn't have any do any written statements for them.
Okay,
I just asked them what they saw and they told me.
I'm gonna object because I had no notice of these witnesses. So, maybe we have to come back another day, finish up, but I'm objecting.
Okay, yeah, I have no problem with that. I don't have any problem with that.
Okay.
You want to interview them?
Yeah. Can you get them for me?
Well, they're sitting outside. I was gonna
I
call
don't
them.
even know their names.
Debbie Caldwell and Kim. Debbie Caldwell. Are we gonna try to come back or what?
No, I'm just gonna, because no matter what, it's still gonna be a question of fact. It doesn't do anything for probable cause.
I don't know this. I didn't do all of that.
so gracious.
Thank you, Judge.
Calling case 1558526. Who has McKnight? You want to?
You're okay?
That's fine. Again, 1558526. People say Michigan versus Kiwante. Is that how you pronounce your name, sir? Kiwante. Kiwante. K-Y-W-A-N-T-E. McKnight. Mr. McKnight is charged with one count of weapon carrying concealed punishable by a maximum of 5 years. Today is the date and time scheduled for
Preliminary exam.
preliminary examination.
Yeah.
Thank you so much.
Christine Longstreet, appearing on behalf of Mr. McKnight.
And Ron Hadid on behalf of the people.
And we're going to proceed today by way of.
Yes, Mr. McKnight has signed his waiver of rights from the exam, and this matter asks that the court accept that, and I'm passing my examination.
Did you hear that?
Yeah.
You're not by a microphone now, so you're going to have to keep your voice even
Okay,
stronger.
sorry,
That's
Your Honor.
fine. All right, any objection from the people?
No, Your Honor.
Counsel, may I avoid your client?
You may.
Mr. McKnight, how are you today? Okay, I'm going to ask you to keep your voice up as well, sir. Mr. McKnight, I have in my hand a form that I'm holding up for your viewing. This form is entitled Examination Waive. On this form, this form details your right to a preliminary examination as well as the purpose. On this form, sir, I see a signature that appears to say Kiwante McKnight. Is that your signature?
Yes, sir.
Mr. McKnight, did you sign this form today?
Yes, sir.
Did you sign this form after you had an opportunity to speak with counsel and an opportunity to discuss your right to a preliminary examination and its purpose?
Yes, sir.
Mr. Kiwante, when you signed this form, was it your intention, I say yours, sir, because counsel is there to assist you, aid you, guide you, counsel you, but it is your right to have a preliminary examination. So when you signed this form today, sir, was it your intention to waive your examination today and address these charges with the circuit court level?
Yes, sir.
The court finds that the waiver is both knowingly and voluntarily given. Mr. McKnight, you will be bound over to the third circuit court for further proceedings. Your arraignment on the information will be July the 9th. Bond is continued. This matter is adjourned.
Thank you.
Thank you. All right, who has Kelly?
Oh, I do.
Calling case 1557616. People say Michigan versus Mr. Daniel Craig Kelly. Mr. Kelly is charged with 2 counts. Count 1, operating while intoxicated, causing death, punishable by a maximum of 15 years. Count 2, reckless driving causing death, also punishable by a maximum of 15 years. Date is the date. How do you read my sheets? The date is the date and time scheduled for preliminary examination. I do have to find my sheets. So. Okay, and how are we going to proceed today? I'm sorry, do we have a hearing?
Good afternoon, Dean. I'm Nicholas Clark on behalf of people.
Good afternoon, Judge. Thomas Watt on behalf of Mr. Kelly, stands to my right. Judge, I've advised my client that the prosecution has burden to show probable cause this crime was committed and probable cause that he committed it. I went through those rights. He's willing to waive those rights and have this found over to circuit court, Judge.
And the people?
People have no objection, Judge.
No objection. Mr. Flores, may I have one at a time?
Please do, Judge.
Mr. Kelly, how are you today, sir?
Good, Your Honor.
Mr. Kelly, I do have in my hand a form. And again, this form is entitled Examination Waive. This form details your right to a preliminary examination as well as the purpose. On this form, sir, I see a signature that is artful. Is that your signature, sir?
Yes, Your Honor.
All right, that's your legal signature, the way you always sign your name, sir?
Yes, Your Honor.
All right, Ms. Kelly, did you sign this form today?
Yes, Your
Did you
Honor.
sign this form after you had an opportunity to speak with counsel, an opportunity to discuss your right to a preliminary examination and purpose?
Yes, Your Honor.
When you sign this form, Kelly, was it your intention to waive your examination today and address these charges at the circuit
Yes,
court level?
Your Honor.
Okay, well, the court finds that the waiver is both knowingly and voluntarily given. Mr. Kelly, you will be bound over to the third circuit court for further proceeding. Your arraignment on the information will be July the 9th. The bond is continued. This matter is adjourned.
Thank you, Judge.
Ms. Kelly, when you come back to this courthouse, you'll come to this courthouse, you'll not come to this courtroom. Your name will be posted down there.
Thank you, Judge. Good seeing you.
Yes, sir, you. We got the adjournment.
All right, hold on. I'll see you later, baby.
I'm sorry. Hussein versus Humayun. Is that how you pronounce your name, sir? Humayun?
Yes, sir.
Humayun Kabir Hussein. Defendant number 1, defendant number 2, Mr. Abdul Muttalib, and defendant number 3, Mr. Mohammed Abdul Jabbar. All 3 individuals are charged with. Now, let's do it this way. Defendant number 1, Mr. Hussein, is charged in count 1, and that is assault with a dangerous weapon punishable by a maximum of 4 years. Mr. Hussein is also charged in count 2, weapons, felony firearm. That's mandatory 2 years consecutively with and preceding any term of imprisonment close to a felony or attempted felony conviction. Mr. Muttalib, M-U-T-A-L-I-B, is charged in count 3, 4, 5, 6, 7. And Mr. Muttalib in count 3 is charged with assault with intent to do great bodily harm, less than murder, punishable by a maximum of 10 years. Count 4, 5, 6 are all assault with a dangerous weapon, each individually punishable by a maximum of 4 years. Count 7, weapons, felony firearm, mandatory 2 years consecutively with and preceding any term of imprisonment close to a felony or attempted felony conviction. And defendant number 3, Mr. Jabbar, is charged in counts 8 and count 9. Count 8, assault with intent to do great bodily harm, less than murder, punishable by a maximum of 10 years. Count 9, assault with a dangerous weapon, punishable by a maximum of 4 years. These matters are all scheduled for preliminary examination today. Yes.
Ryan, have you done behalf of the people?
Good afternoon, Your Honor. Ben Morley on behalf of Mr. Hussein.
Thomas Everett on behalf of Mr. Muttalib.
Good afternoon, Your Honor. Ryan Hill on behalf of Mr. Jabbar.
Very well. Certainly, as anyone who's been in this courtroom today knows, that this courtroom today is very congested, has a case that is going for an extended period of time, and it does not look like there's any way that we can get this case done today. We've made efforts to send this case to another judge, and apparently no one else was available. So, unfortunately, Mr. Hussein, Mr. Muttalib, and Mr. Jabbar, unfortunately, I'm going to have to adjourn this matter. I'm going to have to ask you to come back. I do apologize. I certainly do not want to create any inconvenience to any of you. Certainly, I recognize that you all want to have these matters resolved, but unfortunately, this is beyond my control, and we will have to do that. One other thing, certainly, sir, you are interpreter, is that correct?
Yes.
I do have to swear you.
Yes, sir.
Say your full name.
Sayed Zain.
You want to spell that before the board, please? You got it? And what language are you interpreting?
Bengali.
Bengali. Do you swear to interpret Bengali to English and English to Bengali to the best of your ability?
Yes, I do.
Sir, do you, just a little background question, are you certified by the court and by the state to interpret?
You know, there is no certification for, I told you for record.
There's no certification, but the courts have to recognize you.
Yes, Your Honor, I do have.
And you have been recognized
Yes,
by
yes.
this court?
Yes, sir.
As well as other courts?
Yes,
in the
yes,
state?
Your Honor, yes.
Very well. Certainly, and I did not swear you until after we had put some things on the record. I noticed that you were standing next to Mr.
Jabbar.
Mr. Jabbar, and you were speaking to him. Have you interpreted accurately all that has been said and placed on the record?
Yes, I did.
Very well. All right. Now, understanding that we have to return to another date, we have discussed a date that is amenable to all parties. Is that correct?
Correct.
Yes, correct. All right. And the date that we discussed is January the 1st?
July 3rd.
When was James? It's been one of those kind of days, all right? I apologize. You know, some people wonder how do I sit up here, right? Don't even know the months. But in any event, July the 1st.
Correct.
Did we talk about any particular time?
10 a.m.
10 a.m. All right. Gentlemen, Mr. Hussein, Mr. Muttalib, and Mr. Jabbar, certainly again, I apologize for asking you to return, but again, it is beyond my control, and we will see you at 10 o'clock on July the 1st. File is continued.
Judge, there is one other issue.
There's another issue, yes.
We did submit I believe, stipulated order for discovery. Should be in the file. We're requesting video surveillance from any police cruisers on that date, as well as there was a hammer that was submitted into evidence. We're requesting it be sent to the lab for DNA testing. I don't think there's an objection from the prosecutor.
Certainly, I cannot order the police department or anyone else to produce evidence. Certainly, if they do anything, it can, in other words, let's say, for instance, I say, well, I think this evidence should be tested, and I order the police to do some type of DNA testing and it comes back with your client's DNA on it, then of course everyone will be saying, well, they wouldn't have this if you didn't order it. So, and obviously if the people are not objecting to it,
Sure, I don't know that he can order the police to send the hammer to
no,
that.
no, you cannot, and that's what I'm saying. There are things that can be done on behalf of defense where you can have things done independently. Of course, the police department may do, and I don't know if it's been tested, but I don't have the authority to call the police or anybody else to create evidence.
So, Judge, would that be a request where we can actually set up an independent facility? Is there any objection from the prosecutor if we
I
make that
don't think
request?
he needs my stipulation for that.
Why do we need the hammer, obviously?
Well, the police would have to cooperate in that event, but outside of order, because he does not order the police to create or to, and certainly you can make a request of the police department, but they may be willing to do so, all right? But often people do not have resources to do certain things, and I can't certainly cause them to do something that they may not even be willing to do. So,
I understand that, Judge.
all right, so why don't you just make a request, and you don't have an applicant in charge today.
He's not here today.
All right.
Thank you, Judge.
Thank you. This matter is adjourned.
Thank you very much.
I will assign you order. Okay. What time is it here, sir? Because I'm 9 o'clock. Yeah, 9 o'clock. It is now 1:15. I signed it. So I'm not sure what, on this case of Mr. Jonathan Harville, who's not present today, he's gonna come back tomorrow for, we got a report.
The defendant's not here.
Thank you, Judge. Thank you.
Thank you, sir. We got a report, sir?
Today the people were moving to dismiss it because he's not competent. And it's the 15th month review date and we just processed the civil submitter paperwork.
Yep.
The
We can do it.
attorney
You
of
got
record
some
is not here yet.
Yeah, I'm standing in.
Well, I know I can't do that. We can do it tomorrow.
Okay.
We can do it tomorrow. We'll contact the attorney's record. We'll do it tomorrow. Yeah, people calling down. We can see order.
Oh, okay.
Ms. Miles, your name is on this form, on this file. What's going on in this case? This is Weaver.
Yes, Your Honor.
Mr. Edison, how are you, sir?
I'm great, Judge. How are
Good
you?
to see you, sir.
Thank you, Judge.
What's going on in this case? Oh, so PCC?
No, Your Honor, it's set for exam.
It's set
Set
for
for
exam.
exam.
Well, for the, you gonna call it?
Now call the case. Call the case 1556674, People State, Michigan versus Miss Dana Renee Weaver. Miss Weaver charged with 4 counts. Count 1, weapons, firearm, discharge in or at a building causing serious impairment, punishable by a maximum of 20 years. Count 2, assault with intent to do great bodily harm, less than murder, punishable by a maximum of 10 years. Count 3, assault with a dangerous weapon, punishable by a maximum of 4 years. And count 4, weapons, felony firearm, mandatory 2 years consecutively with preceding any term of imprisonment imposed for felony or attempted felony conviction. Date and time scheduled for preliminary examination. Please.
Good afternoon, Your Honor. Kim Miles on behalf of the people.
Your Honor, Jeffrey Edison, on behalf of Gary Jones, the attorney of record, and also Miss Weaver, who is his client. I'm kind of like passing through, and I understand that Mr. Jones is in another jurisdiction and unable to be here. I did call Mr. Jones. Mr. Jones.
You have permission to speak to his client.
Yes, Your Honor. And however, Mr. Jones needs this matter to be set for Monday, the 29th. He's unavailable to be here today.
You know, I'm always concerned when we have an examination schedule and an attorney knows that they're not going to be in the jurisdiction and the case could not and would not go. so the witnesses could be sworn off and not have to expend a day of their time, energy, possibly losing money because they can't go to work just to have them come back at the end. I believe that is a courtesy, and obviously, Mr. Edison, you are a person who is held in the most highest regard, and I certainly would know that you would not do this, but certainly I cannot understand why if someone knows that they're in court, they know they're in another jurisdiction, why they would not contact the court, contact the prosecution, and say, do not bring your witnesses in because I cannot be here. In any event, Ms. Miles, I don't know that you put your name on the record.
Yes.
I did, sir.
Oh, I'm sorry, I'm probably one of those days.
I understand. So am I, sir.
So, what do we do?
Well, Your Honor, I'd ask that the matter be.
Mr. Jones appointed or retained?
He's retained, Your
Retained.
Honor. That's the issue, Your Honor.
Certainly limits my options.
Yes.
Ms. Miles?
Yeah.
Ms. Jones is retained.
We'll be here.
Nothing I can do with it.
Yes, we'll be here Monday.
And there's something else I should do, but we'll talk about that later. Along with Mr. Jones.
Thank you, Your Honor.
All right, thank you, Your
So
Honor.
what day did we talk about?
Monday, the 29th.
Would Tuesday be a better day for the court, Your Honor?
I'm going to say, Mr. Edison,
All right,
we
that-
can contact Mr. Jones Monday.
I'll let him know.
You know, this is a domestic violence case.
I'll let him know. Tuesday, the 30th.
That would be much better.
All right,
Thank you.
Your Honor.
That would be better for me as well, Your Honor. Thank you.
Thank
All right.
you so very much.
Have a great day,
Always good
Judge.
seeing you, Mr. Edison.
All right, thank you, Judge.
And Ms.
9
Weaver?
o'clock. Ms.
Ms.
Weaver.
Weaver? Yes. And I do apologize to you as well, ma'am, that you come down here, and I don't know if you knew that your attorney was not going to be available, but certainly you should have known, and we all should have known.
Right.
And, well, we'll see you next week,
All right. 9 o'clock, right, Judge?
9 o'clock.
All right.
So what's happening on Smith?
This juncture, there's,
Oh, no, this is Cliff Dixon.
oh,
How many names? There's a Cliff Dixon, and there's a, you have three PCCs. That is Cliff and Smith for PCC? It is. All right. Okay. All right. So, who had Dean Williams?
Daniel Williams.
I show a Dean Williams and I show a Daniel Williams.
Yes, I have Dean.
Okay.
William Dean.
Are these up to date for a probable cause number?
Yes.
All right, so I'm going to call both these cases at one time. If there's no objection.
No objection.
Thank you so very much. Calling case 1255885, People of the State of Michigan versus Mr. Clifton James Smith. Mr. Smith is charged with 3 counts. Count 1, financial transaction device, possession of, punishable by a maximum of 4 years. Count 2, financial transaction device, stealing and or retaining without consent, punishable by a maximum of 4 years. And count 3, identity theft, punishable by a maximum of 5 years. Mr. Smith is also served with a habitual offender second offense notice. And we have the AG here, so appearances, please.
Good morning, Judge Wagner. May it please the court, Richmond M. Riggs, P33863. I'm an Assistant Attorney General. I'm here on behalf of the people in this matter. Good morning, Your Honor. Good afternoon, Your Honor. Warren McAlpin on behalf of Clifton Smith, who's standing to my left.
Good morning, Mr. Smith. Also calling case 1558608, People of State of Michigan versus Mr. Defendant number 1, Mr. William Dean Williams, and defendant number 2, Mr. Daniel Lloyd Williams. Defendant number 1, Mr. William Williams, is charged in count 1, assault with intent to do great bodily harm, less than murder, punishable by a maximum of 10 years. Defendant number 2, Mr. Daniel Williams, is charged in count 2, assault with intent to do great bodily harm, less than murder, punishable by a maximum of 10 years. Mr. William Williams, defendant number 1, is charged in counts 3 and 4. Both are assault with a dangerous weapon, punishable by a maximum of 4 years. Each case or each charge individually punishable by a maximum of 4 years. And Mr. Daniel Lloyd Williams is charged in count 5, assault with a dangerous weapon, punishable by a maximum of 4 years. Mr. William Williams, defendant number 1, is served with habitual offender 4th offense notice. Mr. Daniel Lloyd Williams, defendant number 2, is also served with habitual offender's 4th offense notice. Today's date and time scheduled for probable cause conference on this matter as well. Appearances, please.
Your Honor, Hadid on behalf of the people.
Your Honor, Mary Barnes standing in for Attorney Terry Johnson on behalf of William Dean Williams. With his permission.
Very well.
Good afternoon, Your Honor. Wyatt Harris on behalf of Daniel Williams.
Very well. With regard to Mr. Clinton Smith, have the people made an offer?
Judge, we have discussed it. It is contingent somewhat on our reaching agreement. I do have for the court, with the court's permission, an amended complaint and warrant. It recites essentially the identical charges, but it charges the defendant as a habitual 4th or subsequent. If I may approach and tender.
Very well. Well, certainly the charges have not changed. The serving of notice is a courtesy that Mr. Clinton James Smith is now recognized as a habitual 4th offense served with the notice anyway. So the charges are as read. Is that correct?
Correct, Judge.
And I so acknowledge?
Yes, Judge.
All right.
Judge, I would also ask the record reflect, I have tendered to Mr. McAlpin the discovery that he is entitled to in this matter. Copy of the police reports have been made and have been given to him this morning. He was just appointed today.
Very well, Mr. McAlpin, you acknowledge receipt of discovery?
I do, Judge.
Very well. The people, I do have the probable cause conference form in hand. People have indicated which witnesses would likely be called at the preliminary examination. The form is, however, silent with regard to any reports, records, or stipulation, requests, or other motions to be introduced at the examination by either party. Is that correct?
That is correct, Judge.
That's correct, Judge.
Very well. The scheduled date for the preliminary examination is July the 2nd. Does that create a conflict for you?
Yes, Judge. We agreed to a July 9th date. That's okay with the court.
Well, just do. Is it because that you have a conflict?
Yes,
I can't
yes.
just change the date for it unless there's a reason to do
Yes,
so.
there is a conflict.
Very well. And it's agreed to by the Assistant Attorney General?
It is, Judge. Mr. McAlpin's advised me of the conflict. He's advised that if the court's willing, July 9th would work for him. I spoke to
Okay, I thought it was right. You said 7th. I guess it was tough to go over the two. So it is July the 9th?
Yes, Judge.
I'm glad you said that because I'm looking at what I thought was a 7th. So July the 9th. All right. All right. It's agreed upon by parties. Mr. McAlpine, you, sir, your client, Mr. Smith, is entitled to have his examination within 5 to 7 days of the probable cause conference. Are you waiving that, sir?
Yes, Judge.
I will amend the form and check that block that you have agreed to waive the 5 to 7 day rule. Now, Mr. Smith, you have a statutory right to a preliminary examination. Clifton James Smith, you have a statutory right to a preliminary examination, sir. It is agreed upon by parties that your examination will occur on July the 9th. 9 o'clock, we'll see you on that date, sir. This matter is adjourned by and continued.
Thank you, Judge.
Thank you, Judge.
Okay, Mr. Williams and Mr. Williams. Mr. William Williams and Mr. Daniel Williams. Have there been an offer made by the people on this matter?
No, Your Honor.
No offer made, and saw someone standing next to you earlier. So,
I was.
no, I thought someone else.
Oh.
You must have been. Mr. Daniel Williams, Mr. William Williams, Mr. Daniel Williams, there's no offers being made. Are you requesting your preliminary examination? You're demanding your preliminary examination?
Yes.
Yes, Your Honor.
Very well. I do have the probable cause conference form in hand. Indicates that have both of you received discovery for your client?
Yes.
Yes, Your Honor.
Very well. The people have indicated which witnesses would likely be called. The form is silent with respect to reports, records, stipulations, requests, or motions to be offered by either party. Is that correct?
Correct.
examination is July the 2nd. Does that create a conflict for anyone?
No, Your Honor.
No, Your Honor.
And Mr. Williams, you both have a statutory right to a preliminary examination. The date that is scheduled for you gentlemen is July the 2nd, and we'll see you on that date. These matters are, yes.
My client would like to have a bring forth a motion of reconsideration of bond.
And who heard his first motion? Did I? Your client being Mr. William
William D. Williams.
with a habitual fourth with his last conviction in 2010.
Yes, Your
Or the
Honor.
last one I see.
He has a business, home care
You
business.
know what, I also see that he's had prior armed robbery convictions. I'll send you for a report. I don't know enough about him to reconsider anything at this time.
Okay.
So, I'll recommend they'll do a report for both.
Thank you, Your Honor.
These matters are adjourned.
Thank you, Your Honor.
All right.
Mr. McAlpine's appointment.
Judge, can we see the court back, please?
Yep. Yep.
Yes.
Mic check 1, 2, 3.
Okay, so you're gonna now. You got your numbers. You want these statements. That's all done now. I don't have to worry about that anymore. Not at this particular moment. And if there's a witness that comes up before the trial or anything else, I'm gonna make sure it's all there. All right. All right.
How did that go?
We're gonna work our way through this, okay? All right, good. All right. I'm gonna tell them. I said she wants to. They want to go to work, so I'm gonna tell them if they want to go. They can go. All right.
So you are a witness, so you cannot listen to the testimony of others. You need to step out of the courtroom. Any witness who has testified has to still remain outside the courtroom. Back on the record of 1557895, people say Michigan versus Mr. Virgil Smith.
Good afternoon, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Godfrey Dillard on behalf of Mr. Smith.
Your Honor, defense counsel indicated that he had witnesses that he wished to call. The people are formally objecting to the witnesses that I did not have notice to. I've been in constant contact with Mr. Dillard throughout this 2-week period. He never indicated to me that he had witnesses that I didn't know about. We spoke last night, approximately 5 o'clock. He never prosecutor was going to call. We spoke this morning. He never indicated that these two additional witnesses that he was going to call, and fundamentally he wants to string these witnesses on me at the last minute. I am entitled to due process, which means I am entitled to notice the witnesses and the opportunity to interview them and check out their story before they're testified. That has been denied to me. For those reasons, I'm going to ask the court to preclude those witnesses to testify at this hearing, and of course they'll be free to testify at any future hearing, but because the disadvantage that I have been put at this point, I don't think it's fundamentally fair to allow those witnesses to testify.
And just let me simply say, Your Honor, I object to the motion.
Okay, counsel, but certainly people have indicated that they were denied the opportunity to know who the witnesses were, to interview them, and or to check out their story. So you're asking for me to deny her motion, but you have not given me a valid or a reason to do so. I need to understand why it is that these witnesses, because it is the state's offense to enact legislation that all cases would have a probable cause hearing prior to a week, 5 to 7 days prior to the preliminary examination, where notice of witnesses or any deals or anything of that nature can be worked out. Certainly, we did have sidebar where we had some discussion of this, and you indicated that you did not know of these witnesses at the probable cause conference. However, we were scheduled to do a preliminary examination from a week ago at a point in time where you did know of the witnesses. You indicated the witnesses were here present in court. In fact, they had some contact with the court. I had no idea who they were. After the court had been adjourned, a person came to the courtroom and indicated that they were a witness on the case. I had no idea who they were and that they needed to talk to the prosecution. I had no discussion with the person, but I did attempt to call the prosecution and say that there was someone here looking for them as a witness. I was unable to contact the prosecution, and the witnesses left. So I had no idea who they were. I had no idea their names. I had a conversation with them, and Mr. Dillard, based on our conversation today, you indicated that those were the witnesses that you knew of, and that was their efforts to get in touch with the prosecution. However, it is not the witness's responsibility to contact the prosecution. It is the attorney's responsibility to share and provide mutual discovery. That was not done. That does put the people at a disadvantage. Certainly, it would have only taken a phone call to say I have the witness by this name and available at this telephone number, and that could have been done at any time. It wasn't done. It does create, and I should also note that this is the date and time for a probable cause conference. It's not the time to place all witnesses on the stand, and certainly, if in fact these witnesses were to testify today at a preliminary examination, and they said something that was contrary to what was said today, it is not the role of the judge at this level to make the decision. It is the role of the judge or magistrate at this level to simply listen to the evidence, make a determination if there's probable cause to suggest that a crime was committed, and some type of identification that the accused did that case. If the law also says if there is equal evidence to suggest that it did not occur, then that would be a question of fact or a finder of fact. So even if the witnesses walked in at this point and said none of this happened, it is not this court's responsibility to make credibility judgments and to make a determination that the case should proceed. Once there is evidence to suggest that something occurred, equal evidence suggests that it did not occur, simply creates a question of fact for the finder of fact. So you obviously have the right to put witnesses on, but you certainly have to play by the rules. I'm not at all suggesting that this was done intentionally, because I doubt that it was. But that, even if something is done unintentionally, it still puts the
First, if you both could say and spell your full name.
Joyce Russell, JoyceRussell.
Okay, and what's your title?
I'm the Director of Development and Partnerships.
Okay, and what's your name?
Laura Lawson, Laura Lawson, Chief People Officer for United Shore.
Okay, and what are you guys doing here today?
Well, we are making sheds. We're building sheds for our partner families. We're doing 6 sheds today because in the Habitat model, we don't typically build a garage, and our families need to have a storage facility to put all their wares in their lawnmower and keep their property nice and tidy.
Okay, and who's all here? Like, who are the volunteers?
Yeah, so for United Shore, we know how important it is to be hands-on in our community. We have over 1,200 team members, and today 100 of them get to be hands-on in helping build these sheds for Habitat.
Okay, and is it the first time you guys have built sheds like this? Are people enjoying themselves?
It is the first time we've been able to do this. We've had a 3-year partnership for Habitat, and this year we finally get to have something on site in order to help our team members just step outside, be hands-on to build these sheds, and then Habitat's going to deliver them to families in need.
And I think that this is a unique opportunity, and we love to bring these unique opportunities to our partners who help us build homes in Oakland County. Habitat for Humanity is part of a $3.2 billion brand, but we have to do our fundraising locally in our counties. So we can only do it with our partners like United Shore, who help us offer the dream of home ownership to low-income families.
And as a residential mortgage lender for us, it makes sense, the partnership with Habitat, because we're fulfilling the American dream and so are they. So it's a brilliant partnership for us.
Okay. And how does it feel to be able to get everybody out here? You're doing something good for the community.
I have chills right now. I have chills. It's very exciting. This is a great day for Habitat and United Shore and our teams.
Yeah, we know how important it is to be hands-on. So it's great to be able to get people out here, and it strengthens our relationship for Habitat.
Okay. You think this is going to be something you guys will do again?
Yes.
We hope to make it an
We
annual
want
partnership,
to.
regardless of if it's sheds or not.
We
We
would
have
love
a strong
to.
partnership
Right.
that's going to go forward.
Yes.
So whether it's volunteering, hands-on,